All right, let's call the meeting to order. Welcome to the last of our joint interim corporations committee meetings. At least I assume it's the last one. Could we have roll call, please?
Good morning, Mr. Chairman. This is roll call for joint corporations, elections, and political subdivisions for October 22nd, 2024. Senator Barlow?
Present.
Senator Boner?
Here.
He's present online.
Senator Landon?
Here.
Senator Scott?
Here.
Representative Chadwick?
Here.
Representative Haraldson?
Here.
Representative Harshman?
Excused.
Representative Knapp?
Here.
Representative Newsom?
Here.
Representative Ottman?
Present.
Representative Wiley?
Here.
Representative Yin?
Here.
Co-Chairman Case?
Present.
Co-Chairman Olson?
Here.
We have a quorum.
And actually, Katie, I excused Representative Harshman, but is he online? Oh, okay.
You know, those football people, they're probably at the training breakfast right now or something. All right, well, just a reminder to everyone to please sign in the back. That helps a lot with the staff and organizing the testimony. And Chair would entertain a motion to approve the minutes of our last meeting.
So moved.
Got a motion by Landon. Any discussion? Second over there by Newsom. Any further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Minutes stand approved. This morning, we'll jump right into our electricity discussion. I would guess that's what's going to be by looking at the faces out in the audience. There's a couple things. Our subcommittee on electricity taxation has been working diligently, hired a contractor. The contractor has produced the first kind of preliminary report. The subcommittee hasn't received that report yet. They've seen copies of it, but the contractor is going to make a presentation next week. And then after that, there'll be reaction to the report and probably revision, and then we'll go from there. And that's really all I have on the electricity tax subcommittee. If there's any questions, I'd be happy to entertain them. Representative Wiley's on that committee from this committee. It's also made up of folks from the Revenue and Minerals committees. Questions? Senator Barlow.
Thank you, Mr. Chairman. So what do you perceive will be the process? You're receiving a report, you're going to give feedback, et cetera. Is that report going to be issued at some point? Is there going to be a follow-up to what committee, et cetera, before the 25 legislative session? What do you anticipate? Thank you, Mr. Chairman.
Thank you very much for the question, Senator. So the report is sort of like counsel. It's a written report from legal counsel, and we're treating it as privileged at this point. And we're going back and forth with the council among the subcommittee. By the way, Representative Harshman's also on the subcommittee. At some point, indeed, it will be made public. It would be within the purview of members of any of those committees to move something forward into the next session. And the idea would be to have a bill for the next session, maybe just dusting off the bills that we've had before. But until whether the Corporations Committee wishes to be more involved in receipt of that report and maybe have an additional half-day Zoom meeting or something to approve something going forward, that's up to this committee. But we'll all see the report. Anything else on that issue? Thank you. Josh, can you help us with the net metering court decision that had come about in the past week? The reason this is on your agenda is it's just a relevant factoid about our net metering law. So there was a significant court decision affecting our friends in the cooperative utility industry. Josh, I yield to you.
Yes, sir, Mr. Chairman. So I'll just give you a kind of a brief overview of the case. So it was Powder River Basin Resource Council versus the Wyoming Public Service Commission. The decision was issued August 30th, so fairly recent case. As Senator Case noted, Chairman Case noted, the case dealt with net metering, which is provided for in statute 3716-101 through 104. And those statutes provide for the treatment of customer generators who have installed their own personal electrical generation equipment, and provides for compensation to those customer generators if they provide more energy to the utility than they use. The case dealt with two different provisions of the net metering statutes. So there's a monthly compensation that's under 3716-103A, paragraph 3, and then there's an annual true-up provision under 3716-103B. Those two provisions, the monthly provision provides that the customer generator shall be credited or compensated for excess kilowatt hours generated during the month with a kilowatt hour credit or compensation appearing on the bill for the following month. Then in subsection B, the annual true-up says at the beginning of each calendar year, any remaining unused kilowatt hour credit accumulated during the previous year shall be sold to the electric utility at the electric utility's filed avoided cost. So in the case, High Plains Power is a co-op electric utility. They had 94 customers who were using net metering. And how they would do that, when they would have a monthly customer that had more kilowatt hours than they used, they would provide a monthly credit on their statement in the form of those kilowatt hours to be used in the following month. High Plains applied to the Public Service Commission to revise how they provide that compensation. And instead of providing that kilowatt hour credit, they were looking to compensate the customer generators based on their avoided cost, which is essentially the wholesale cost for when they purchase power. The Public Service Commission approved that as part of the tariff revision for High Plains Power. This essentially changed monthly reimbursement from the retail rate, because as you're getting your kilowatt hours, that's essentially avoided retail cost the following month, changed that to the wholesale rate. Powder River Basin Resource Council and others appealed that, and the case was then certified to the Supreme Court. The Supreme Court reversed the decision of the Public Service Commission. They found that avoided cost language was only found in the annual true-up provision and could not be essentially read into the monthly reimbursement provision. The court found that there was nothing in that monthly reimbursement language addressing how to calculate monthly credits. And because of that, the court found that the legislature intended for the Public Service Commission to essentially determine the monthly reimbursement rate on a tariff by tariff basis. The court then kind of found that the PSC did not make a determination in the case based on the evidence, but rather based their decision on the interpretation of the statute. And the court noted that High Plains would have the burden to prove that the proposed rate change is just and reasonable as with a normal rate case. There was a concurrence in the case. Two justices concurred separately. They agreed with the majority decision to reverse, but they read the two statutes together and found that it was plain that the monthly rate had to be either a kilowatt hour credit or compensation at the retail rate, because otherwise, if you read those two provisions together and monthly reimbursement could be done using avoided cost, there would never be any excess credits, and subsection B would be superfluous. There would never be a need for an annual true-up. So that's the case, Mr. Chairman. I'd take any questions.
Thank you very much, Mr. Anderson. Any questions for Mr. Anderson? Representative Yan.
Mr. Chairman, thank you. Mr. Anderson, do you know if there was any dissent among the PSC when they made their original decision?
Mr. Chairman, Representative Yen, yes, it was a 2-to-1 decision on the PSC.
Anybody else? Questions for Josh? Yeah, Senator Scott.
Mr. Chairman, couple of questions. Mr. Chairman, the avoided costs strike me as rather different than the wholesale rate. Is there a confusion there? Did we not define avoided costs? And I guess that's in good part my question. And what's the practical effect of the decision?
So, Josh, you don't have to jump down the avoided cost wholesale rate unless you want to. Go right ahead. And then
Sure.
PSC can help us with that too.
Yeah, certainly would be willing to defer to others, but essentially it's a filed rate with the PSC. But the court essentially equated it with wholesale costs. It's not exactly that, but that's essentially what it's, from my understanding, what it's meant to convey, or meant to be an approximation of their wholesale cost.
Yeah, and Senator Scott, I would say in this, for this purpose, it's kind of a rough equivalence. And the second part of the question, if
And
you
the second
wish.
part of the question, Mr. Chairman, so I think the impact of this case is, based on the majority opinion, I think it'll be up to the PSC and each individual utility to through rate making, determine what that monthly credit rate would be. It wouldn't necessarily be the avoided cost or the retail costs. It could be any cost that through the general rate making process that they can defend as a reasonable rate.
I might tag on to that part too, if you don't mind. So I think the practical effect is what this does is take our friends in the co-op world who argue that because they're not under active rate regulation, that they could kind of do this in a different way. The courts seem to come down pretty squarely and saying, no, you have to do it the same way that the investor-owned utilities do. Meaning net metering is offset by the retail rate, and if there's excess over a year, you can go down the avoided cost rate or the wholesale. So it brings small co-ops into the fold of the industrial utilities like Rocky Mountain Power, Black Hills, to have the same policies. And it'll have implications for them. It'll probably put more pressure on our net metering statute because it increases the amount of distortion, especially in rural areas in these customer-owned systems where they see it. You know, they set those rates and they understand who's getting hurt and who's not. So I think this is going to evolve our policy in a significant way over time. It's going to put pressure on it. Senator Scott.
Mr. Chairman, is what you're saying is that the rates of the people who don't have the rooftop solar sort of stuff are going to go up because of this decision?
For the cooperatives, yes, it's quite clear. There's no other way. They'll be compensated more. It's got to come out of the general, the rest of the customers. So it brings to the forefront the problem that we have in Wyoming that we really do have to fix, you know, at some point. And we've tried it before, but we haven't thoughtfully brought it forward. This allowed a lot of rural Wyoming to escape from that. They're now going to be included in those requirements, and the distortions could be more significant. Senator Scott.
Mr. Chairman, do you have a current notion of how many states currently have fixed this problem and how many have not?
Not a precise count. I know that in the West, the problem has, more states have adopted changes. Even California's made changes, Utah's made changes, other states. There may be other witnesses that can kind of testify to the general nature of that. It only gets worse as there's more rooftop solar wanting this subsidy in the market and hurts other people more and more every year. So we're gonna have to deal with it. But I appreciate Josh. Should we let him off the hook if there's no more questions? And there'll be public comment on this whole area too. on the electricity day, so let's try to get through that agenda if there's nothing else further for Josh. Thank you, Josh. Public Service Commission, do you have anything to help us with? You can certainly help with this matter if you want, or generalities about your docket and how it's going. And if you can come up after the proposals from the utilities as well, you're welcome to. We're not. Make sure your green light's on, Mr. Petrie. Thank you.
Good morning, Mr. Chairman, members of the committee. Just a quick update on our docket. We have two significant Rocky Mountain Power proceedings underway. One is a power cost adjustment case, and one is a general rate case. Those are significant cases requesting significant increases, and they're relatively early in the process. The power cost adjustment case rates are in effect on an interim basis as provided for by their innovative rate-making tariff that deals with their power costs. Other than that, we have a couple of important rulemakings in progress. One is for
Does everybody hear Mr. Petrie okay? Okay, just checking. Thank
too
you.
far from the microphone.
Well, those don't have green lights, so I thought you were online. I'm just checking, I'm sorry.
Mr. Chairman, we also have two important rulemakings underway. One is for establishing a process by which the commission could determine whether a non-utility generator could operate without becoming a public utility. And that is inspired by the possibility that new generation for large customers appears. If you think about micro reactors and the like, that's meant to create a process that would provide some certainty for any industrial operations or third parties that might be interested in engaging in that activity, generating for one or two large customers without becoming subject to PSC regulation. The other is to establish an IRP process that's more involved than what the commission has customarily done. And as you all know, the commission's historic habit is.
You might define IRP.
Oh, I apologize, Mr. Chairman. That's an integrated resource plan. That's where particularly the large vertically integrated, meaning they may own generation, transmission, and distribution components of an electric system. They generally engage in a long-term planning process so that they're looking out to a 20-year approximately horizon to form an idea about what they'll need to do between now and then to maintain their service. And then those also typically include what we always call an action plan, which is a shorter term, maybe what the utility plans to do in the next 5 years. So the commission has generally in the past received those integrated resource plan filings, reviewed them, provided for public comment, and then accepted them for filing without taking any more formal action on those. Their plans, the idea has always been that any particular thing that the utility determines it must do or that it should do would come to the commission under a certificate of public convenience and necessity application. Then the commission would determine whether the utility's proposal was consistent with the public interest and reasonably necessary for the public well-being going into the future. And then the costs would be addressed after that, even in a general rate proceeding. So the idea here is to take a more involved approach to the planning process itself rather than waiting largely for actual applications to build or do things.
Thank you very much, Mr. Petrie. Any questions? Questions, Senator Scott?
Mr. Chairman. Questions on some other electric matters, Mr. Chairman.
I think it's fair game.
Mr. Chairman, I'm seeing, going by the ranch every day, a lot of wind turbine components. And I think there's quite an expansion going on to the south of me, down Shirley Basin and further south and west. And I'm also got a proposed solar, industrial scale solar project been proposed in my district. Got a call from a constituent as opposed to that. And a couple of questions relating to that. My understanding is that you have a process where you approve construction of these things, but don't then admit it to the rate base at a later time. Is that a correct understanding?
Mr. Petrie?
Mr. Chairman, Senator Scott, I'm not sure I've got the question exactly right, but I'll take a try. First, many of the renewable generation projects that you see in the state are not, they're not utility projects, all of them. Many of them are built by other than the utility. They connect to the utility, they connect to the transmission system once they come online. But many of the projects you would see go through industrial siting, but not necessarily the Public Service Commission until such time that the utility has made an arrangement to purchase that power. And then we would examine the arrangement for buying that power to make sure that those were prudent power purchases. Some is owned by the utility, but
Okay, and
Senator Scott?
Mr. Chairman, that was very useful clarification. So the utility is going to buy the power in many cases, but they're not the ones constructing it. If these things are heavily subsidized currently, is my understanding. If those subsidies were to go away after the election, when maybe some sanity returns and they start worrying about how much deficit is accumulating in Washington, would that make purchasing that power irrationally expensive? Or how does that part of it work? And Mr. Chairman, second question I have with regard to particularly the wind is I'm hearing a lot of complaints that we are not adequately bonding the wind power to recover all the costs, and specifically that we're not recovering the costs of removing all that concrete they're putting in the ground and going to create ourselves a long-term problem. And I am hearing that from constituents.
Senator Scott?
Mr. Chairman.
What fun we're having here this morning. Go ahead.
Mr. Chairman, the latter first, again, to the extent that some of those projects are not utility projects, they're private enterprises, and as you note, and it's widely believed that subsidization has encouraged more of that than you would otherwise see. Many of those are not public utility constructed projects. And so whether bonds are being required on those sufficiently for removal eventually, I don't really know a lot about that. That's kind of industrial siting field rather than Public Service Commission. They're not utilities. We only regulate utilities. And as far as the utility constructed wind or solar facilities, and I understand the large concrete foundations that are associated with the very tall wind towers are what you're mostly talking about here, I think. I have never thought that it's particularly wise to require the additional expense of bonding in the case of public utilities because I believe that the Public Service Commission is in a position to require the utilities to complete their cleanup in the event that they remove these facilities. Now, as far as what might happen due to events in Washington and the cost of purchasing power from these renewable generation facilities, we would maintain our normal posture, which is that you have to buy power in a prudent manner. It has to be at a reasonable rate. And if that power becomes exorbitantly expensive because, say, a subsidy is removed, then I think the utility's approach to purchasing that power would probably have to change. Something would have to change in the relationship between the generator and the utility, because the Public Service Commission is not empowered to allow recovery of unreasonable costs. So if that power is not the most reasonable move, if acquiring that power is not the most reasonable move for that utility to make, there would be questions about being able to recover those costs. And I think they would stay far away from that.
Mr. Chairman,
Senator Scott?
one final question. What percent of the new renewable generation that we see is utility-owned, and what percent is owned by these private generators? I understand it's largely the private generators, but there's some utility. What, do you have a ballpark as to what the percentage is?
Mr. Petrie, if you
Mr.
can.
Chairman, I don't have a solid percentage at my fingertips. I'd have to look into that. Senator Scott, we could certainly get that to you.
Perhaps when Rocky Mountain Power or Black Hills come up, they could talk about what the makeup of their new generation is. That'd be interesting. Thank you. Anything else for our Public Service Commission? So can you, without getting into case details, how big is the application of Rocky Mountain Power's general rate case? What percentage increase in rates would that be?
Mr. Chairman, I believe that is, that's approximately 14.5%, 14.7, that neighborhood, 123 million.
And then just by way, you had another one of these last year, right? What was the request last year and the final disposition of that case from last year? Do you remember?
Mr.
I don't mean to put you on the spot. But
Well, Mr. Chairman, I'll try to answer. I think that it was in the neighborhood of 20%, maybe slightly above 20%, and then I think that the outcome was 8 to 9%.
that sounds rough. Got roughly correct, and got nodding in the background. So just by way of the lay of the land, that was last year. And this year, there's another one going on that's almost the same size. And when you add in the automatic adjustment clause, what's that term for the power factor you're talking about? That's not the right term.
Mr. Chairman, power cost adjustment mechanism. It's an innovative rate-making tariff that's basically intended to perform the function that a commodity cost pass-on performs, but it's a more complicated affair because this is vertical integrated utility with, some degree of control over its power costs, as opposed to like an electric co-op, which has a generation and transmission co-op that generally gets all or most of its power from and really has no control over it. So,
And Mr. Petrie, would it be fair to say that it's an automatic adjustment mechanism that accounts for things that are not within the utility's control, such as fuel, natural gas, or purchase power, or there could be other things. I don't know what's all in it. But that's the idea, is that there's no need to cut, you shouldn't have to do a rate case for those things that are known and pass through. And just by way of putting things in perspective, you've got another one of those now, and you had one of those last year. Do you remember roughly the magnitude of those requests on top of the rate case requests?
Mr. Chairman, the current request is 84 million.
What's that
And-
percentage terms? I'm sorry.
I think that's about 10%, about 10%. Mr. Burbridge is telling me 11%.
Okay. And that's on top of the 14% general rate case.
Mr. Chairman, those are parallel proceedings.
Right, they're additive. And then last year, you did have a general rate case. You came in with substantial less, but at the same time, there was one of these same power cases, adjustment clause cases, or proceeding. And what was the happen there? Did they ask for so much and got zero, or did they end up taking some away?
There was a power cost increase.
Was it what they asked for or close to it?
I believe it was,
It's not wrong to say that it was. I'm not making criticism. I'm just trying to illustrate the magnitude of the cumulative impacts on power costs.
Mr. Chairman, it was a significant increase. I believe that it was the large part of what was requested.
Right. So, committee, the whole point of this is that these changes in the industry are cumulative and, you know, roughly what's being requested now is about what was being requested last year. And you remember the outrage that we saw last year. And this year, it's kind of more subdued, but it's just like your jaw is dropping. These are expensive times to purchase apparently the cheapest energy available. That was an inappropriate comment probably, but Senator Scott.
Mr. Chairman, looking strictly to last year's case, which been decided, and so you don't have to deduct on risk of prejudicing you on this year's, what percent in the power part of that case was purchased power from these renewable sources, particularly the windmills, which I guess is last year would probably be all of it. What percent came from that, and was that power at a higher cost than their other costs of power?
It's just, Senator Scott, we kind of have to be careful. It's kind of a hard question to answer because they may set out to buy renewable power at very cheap rates. Sometimes it's negative priced on the market. But the performance or the ability to get the power when it is available means they have to buy other types of power that are not renewable. So you look at what happens, and they actually ended up buying more thermal power than they had expected to, which is could be very expensive. Now, I'm not saying that's exactly what happened, but I'm saying the question is more complicated like that.
Okay, thank you, Mr. Chairman.
Yeah, and Mr. Petrie, did I kind of go down the right track?
Mr. Chairman, you did. The power cost, the determination of the appropriate power cost for Rocky Mountain Power particularly is not exactly simple. There are a lot of things that can affect their plans and affect their results. We've seen, for example, coal transportation difficulties, a big coal mine fire in Utah. These things can really throw your expectations into a bit of chaos, I guess. And I don't know that we can, I can't, as I sit here, tell whether renewable generation that Rocky Mountain Power purchased and provided to customers was a bigger cost driver than any other type. I mean, I could get back to you on that, Senator Scott, but I'm not confident to speak to that.
Anybody else?
Mr. Chairman.
I'm sorry, he has his hand up, and then we'll go to you, Representative Wiley. Representative
Mr.
Knapp,
Chairman.
welcome.
Thank you. Just a quick one. Can you remind us what that rate increase was last year in percentage?
Mr. Petrie.
Mr. Chairman, the application was for a little over 20%, I believe, and the general rate increase, I believe, came in at around 8%. That case is on appeal, however, and subject to federal litigation as well.
Yeah. Representative Wiley, was that okay, Representative Wiley?
Mr. Chairman, thank you. When is the multi-state protocol up for renegotiation?
Mr. Petrie. Would you want to
Mr.
mind
Burbridge.
saying what that is?
Thank you, Chairman Case, John Burbridge, Chief Counsel for the Commission. Rocky Mount Powers has suspended the negotiations pursuant to a term in the existing multi-state protocol that allows the company to suspend those negotiations based on their determination that there was such a divergence between the 6 states that an agreement could not be reached. The current protocol will expire or come to an end at the end of 2025. At this point in time, there are no discussions between the 6 states and Rocky Mountain Power to attempt to negotiate another allocation agreement. And so it would appear to me that the next steps, if there's going to be any attempt at an allocation, would be coming directly from the company in the form of an application, or not. We just don't know.
Yeah, thank you.
Mr.
So,
Chairman.
Mr. Representative Wiley.
So, what does life for Wyoming look like post non-agreement on a multi-state protocol?
Want to speculate on that?
I'm going to turn this back over to.
That's why he makes the big bucks, right? Oh, wait, I think not. Mr. Petrie.
Mr. Chairman, Representative Wiley, there will be a cost allocation regardless. So if there is if there's no multi-state protocol or other agreement, then that will mean that the utility would have to potentially go to each state and propose an allocation of costs for that state to bear. And so there will still be a process. It would presumably become part of general rate proceedings where the utility would have to come in, propose to the commission a means of divvying up the system costs, and then they would be doing that throughout their territory. So the fate of Wyoming is that the Public Service Commission, in the absence of some kind of an agreement, would consider the evidence put forth by the company and interveners in the general rate case and make those determinations. Basically, it adds a complicated additional component to each general rate proceeding if you don't have some kind of a system for divvying up those costs.
Thank you, Mr. Petrie. So this morning, as we kind of go down these questions about rate increases, what's happening with Rocky Mountain Power, and on and on and on, this is not to set the stage to feed them to the lions, okay, when they come up. But what it is saying is the difficulty of the utility business right now. And the Pacific Corp family have kind of decided that they can't hold the 6 state regions together with the same policy. And that includes Washington, Oregon, California, and then Idaho, Wyoming, and Utah. Rocky Mountain Power serves Wyoming, Idaho, and Utah. Pacific Corp serves the West Coast states. It looks like there's going to be a drifting apart of the goals. And that's not all bad from people in the West point of view. And I think we're evolving our relationship. We're going to hear about this with these proposals, with these companies, that we need these utilities desperately, you guys. And they need to be healthy and be able to exist in the political landscape, the financial landscape, and keep the power on for us so we can grow. So I can feel that we're moving from antagonistic over these rate cases to maybe trying to find solutions together. And I hope that's a stage setting for this morning. But it's been some serious water under the bridge. Representative Knapp.
Mr. Chairman, thank you. Yeah, I think it's important that we don't blame utilities when they're another cog in the wheel too. But my question goes back to something that the PSC has authority over. So the no recovery of unreasonable cost. And we've seen a 14.7, 11%, 8% increase. In that thought process, there's typically 3 things, spot market being one of them, infrastructure recovery from wind, and in the future, CO2 sequestration recovery has not even kind of scratched the surface yet on recoverable costs. So do you see those two, I think, a matter of culture and yet having a unreasonable cost colliding in the future?
Mr. Petrie. We're into big pictures today. It's okay.
Well, thank you, Mr. Chairman and Representative Knapp. The Public Service Commission, I've said this to all of you many times, our job is to make sure that we have safe, adequate, and reliable power or other utility service at just and reasonable rates. And just and reasonable rates means just and reasonable rates under the circumstances. We can't bleed the utilities dry to keep rates down, or we ruin their finances and we ruin their ability to do their job. They're subject to a lot of outside forces. You've got federal environmental regulation, you've got fire issues with tremendous judgments levied against public utilities. You've got consequent drastic increases in insurance costs. And the bottom line is that while we're very concerned about rate increases, that's the core of our job, is to make sure that the rate increases that do occur are necessary for accomplishing the goal of safe, adequate, and reliable service at just and reasonable rates. And the utilities are operating in a very tough environment. Not to discount by any means the impact on residential customers, businesses, commercial operations, the effects on economic development, and all the rest. But we do have to take account of the circumstances that exist while the utility is performing its duty.
Senator Scott?
Mr. Chairman, as in terms of the pressures that are constraints on what the Public Service Commission can do, am I right in thinking that there's a string of court precedents going back into the 1870s that says that you have, if you're going to regulate the rates, tell them how much they can charge. You have to allow them to earn a rate of return on their investment, and that those precedents are based in the federal side on the Fifth Amendment, and the state side on almost identical language in the 14th Amendment. And that those are really some of the key constraints that you operate under. Is that a correct understanding? Am I missing something here?
Mr. Chairman, Senator Scott, that's essentially correct. I would add one subtlety to that. And what we're required to allow them is a reasonable opportunity to earn a return. So this is often misunderstood. There is no guarantee that a utility will earn a return. The way it earns a return is it gets rates that, if they are prudent managers of the utility and prudent operators of the utility, those rates should allow them a reasonable return on their investment and the financial, and also to recover their prudent expenses, which I think you've got that right. You know, the part of the issue here is that utilities need access to capital. They need to be able to borrow capital. They need financial well-being sufficient to allow that. So that all knits together, but the bottom line is that the law requires they have an opportunity to recover a reasonable return on their investment.
Anybody else for the commission? Thanks a lot. Stay close by. You'll be back. Thanks. We do have a bill draft. It was one we requested at our last meeting with respect to our friends in the municipalities. And Josh, do you want to help us with that? And just by way of a heads up, I think we're going to flip the utility cost recovery and large electrical loads discussions at the request of the presenters. So Josh, to you.
Yeah, Mr. Chairman, so this is 25 LSO 27, Working Draft 0.5. This bill was actually requested at our first meeting in Lander, and then the committee walked through the bill at the last meeting in Evanston. And after discussion, it was forwarded to this meeting with no amendments. Just real quickly to go through the bill, it does essentially two things. It clarifies that municipalities can construct electricity production facilities, and then provides that they can sell electricity wholesale, subject to an agreement with a public utility. So on page 2, that first change there, this was another potentially conflicting provision, and just the intent of that first section is just to clarify that it's not limiting anything that they're otherwise granted by law. Then bottom of page 2, here it specifically gives municipalities the ability to establish, construct, maintain, and regulate electric light plants and electric power plants and other electricity generation facilities. Over to page 3, again, giving a city the ability to issue and sell revenue bonds for the following types of improvements, including electrical systems in any facilities located on municipal property for the generation of electricity. And then the new language there at the bottom of page 3, the municipality may operate electrical systems for wholesale energy production subject to agreement with the public utility that has the municipality or portion of the municipality in their certificated service territory. And then on page 4, that change is just to clarify that a municipality operating one of these is not a public utility. And then on page 5, clarifying that they're not a customer generator for purposes of the net metering statutes. So that's the bill, Mr. Chairman. I take any questions.
Thank you, Josh. Any questions for Josh? Senator Scott?
Mr. Chairman, page 3, lines 13 through 15. Electrical system speaks to the city or town can sell revenue bonds for, and then these electrical systems in any facilities located, the language was within or without the state, and this says on municipal property for the generation. And my question is going to be, why is that change? My memory is that the existing law is
Better.
worded the way it is so that the municipalities could participate in the Laramie River Station. And that they needed that language that on the within, I suppose the without is not important, but within the state. And here we're repealing that and saying it's got to be on their property. This strikes me as precluding them from getting involved in a similar arrangement where they were throwing in with the cooperatives in the construction of new. So what is that? Why are we making that change?
I think you'll find more instances than Laramie River. I think Senator Barlow's got a couple of examples. So, yeah, back to you, Josh.
Yes, Mr. Chairman, yeah, I think that was just the initial request back in Lander was that cities were wanting to do this on property within their, that they owned. Certainly could have some unintended consequences. But that was the reason that we made that change, was just to clarify that it was, they couldn't do this anywhere, but maybe that was unnecessary.
Any other questions for Josh? We'll look at that. Let's hear from Mr. Collins, or Mayor Collins. You were a proponent of this bill, so why don't we start with the proponent and then we'll hear from everybody else. Am I worried that the taxpayers and the municipalities are colluding?
Mr. Chairman.
I didn't know that. I'm sorry, I apologize. Go
No
ahead.
problem. Mr. Chairman, my name is Ashley Harpstreet, for the record. I am the new Executive Director of Wyoming Association of Municipalities.
I see.
WHAM is a private nonprofit 501c6 association that provides educational resources to our 99 municipalities. Since 1967, WHAM's mission is to advocate for cities and towns' common interest in that WHAM supports policy that allows local decision-making closest to the 68% of the people that live within our borders. Mr. Chairman, I am pleased to say we have all of our parties in WHAM supporting common interest with supporting this bill. We've worked hard to amend and address the issue that Senator Scott just mentioned, and I'm going to turn this over to my colleague, Mr. Mayor Collins from Cheyenne.
Thank you very much, Mayor Collins. Welcome.
Mr. Chairman, members of the committee, I'm Mayor Patrick Collins from the city of Cheyenne. I really do appreciate the committee taking on this topic of allowing municipalities the opportunity to partner with our local certificated utility on the production of electricity on municipally owned properties. I think cities and towns have a similar goal to the state legislature in that we're looking for ways to create new revenue streams to support our operational needs. It was my hope when I proposed this legislation that we could take non-productive pieces of land, like our closed landfill, and make it financially productive by constructing a solar farm on that land. There's numerous grants available that would pay for at least half of the cost of constructing this solar facility that will make it financially viable and help the city fund our operations. And I hope it would actually give other communities a similar way forward to do revenue generation. Currently, our state statutes don't clearly support our ability of cities to do this. We've worked with utilities across the state because we don't want to be in competition with the certificated utilities. And the language in the proposed bill requires that any city-owned generation facility would have to have an agreement with our local utility. Now, there are 12 cities that are municipal utilities. This would not count for them. They obviously have that right. This also answers the question and the concern I've heard about us becoming a third-party generator. We don't want to compete with our local utilities. Now, to Senator Scott's point, I shared this bill with Gillette last week, and we learned that our changes on page 3, starting on line 14, would hurt their ability to act as a municipal utility. We have an amendment that would protect the municipal utilities like Gillette and Torrington, but would still give the 87 other municipalities in the state the opportunity to invest in their future. The amendment restores the necessary language, but it also creates a new section C that incorporates the language giving municipalities the ability to partner with our utility and build electric generation facilities on municipally owned lands. Now, I would like to say that with the effort that's been going through the legislature to give well-deserved property tax relief, our local governments are going to see a reduction in our revenues. I called our Laramie County assessor this morning, and we've had 2,229 people already apply for the long-term homeowner exemption. He feels like that number will be someplace between 3,000 and 3,500 people. So if it doesn't happen, even today, that will cost the city of Cheyenne on our average home $338,808. And so my goal here is to find ways that we can create some local revenues to offset some of the costs that will be headed our way. And so if he's right and we get to 3,000, 3,500, we'll be in excess of $500,000 in losses to our property tax revenues in the next year. And so anyways, we would ask for your support. It's hopefully a simple bill that would allow us the ability to create an electrical generation facility on city-owned properties, partner with Black Hills Energy here in Cheyenne's case, and hopefully find some revenues that would offset some of our losses. And I would stand for any questions you might have.
Questions for the mayor? Questions for the mayor? Senator Scott.
Mr. Chairman, question I've got is, as I read this, and tell me if I'm reading it wrong or not, you're intending to have the city build and operate these electric facilities as opposed to just leasing the land out to some other party to construct and operate the facilities. Is that right?
Mr. Collins.
Mr. Chairman, through you to the senator. Yes, sir, that's correct. Leasing the property gets us small dollars, but being able to be a partner or own that facility would give us the ability to create a lot larger revenue stream.
Senator Scott.
Mr. Chairman, so if we pass this bill, this then would allow for the public, in this case municipal, ownership of the means of production. Is that right?
Mayor Collins?
Mr. Chairman, through you, yes, sir, Senator Scott. But I think the key thing I want to make sure you understand is we're not looking to become the utility and distribute electricity to the individual users. That's what our utilities do. What we're looking to do is to create electricity that we would sell to our utility and they would distribute to their customers at a wholesale level.
Any other questions for the mayor? Any other questions for the mayor?
And Senator, Mr. Chairman, if I could.
I got a question over here, sir. Senator Landon?
I'm sorry, Mr. Mayor, just real quickly, I wonder if this precludes any conversation you might have with one of the power companies to directly affect a municipality's ability to directly provide an electrical source for something you're doing within the municipality. I noticed that the language in the amendment is carefully crafted to say that you can't do that. You can't produce electricity to benefit yourself. Does that preclude any kind of conversation that you could have with one of the power companies, for example? Does that make sense? That door is pretty tightly shut with this amendment. I'm just wondering if there might be an opportunity to come to some kind of an agreement.
Mayor Collins?
Mr. Chairman, through you to the senator, I hope that that's not the case. We would like to be able to, maybe put a solar panel on one of our roofs to help offset, the cost of operating that building. I hope this does not preclude us from being able to do that. That's not our intention. Our intention, though, is to, well, you know what I'm doing. You understand.
All right. You were going to make another point, Mr. Mayor?
That's okay, sir.
Thank you. Any other questions for Wham and the Mr. Mayor? Representative Harrelson.
Thank you, Mr.
Glad
Chairman.
you're here today.
I'm glad I'm here too. Mayor Collins, thank you for coming out today and an interesting conversation. The only concern and question I guess that I do have is, do you feel that this could turn into a bit of a fight potentially, where our municipalities are really driving hard after becoming producers in a sense and being a competitive for our co-ops and our mainline producers? And as you've had these conversations, what have you been seeing and what have you been hearing?
Mr. Chairman, through you to the representative. Sir, I hope not, and I don't think so. We really tried to make sure when we wrote this that we would be providing electricity that the utility already needs, that there's a demand for electricity and they're looking for somebody to provide that. We wouldn't get any special treatment. We would be a vendor just like anybody else would, and we would supplement the demands. And in Cheyenne, we have 7 large data center campuses coming online. We have advanced manufacturing. We have a lot of demands on electricity. We're going to go from 350 megawatts to, who knows, 1,000 or more in the next 5 years. So there's going to be a lot of demand for that, and we might as well, be a part of that if we can. In areas where there's no growth and there's no demand, then you would not be able to do that because you have to have a partnership. There has to be a demand for that electricity. And I think in a lot of parts of our state there will be, and there's some opportunities for us.
Anybody else? Mr. Mayor, I'm just trying to think if this bill were in place back before the city of Cheyenne leased all the towers for the wind turbines that surround your fair city. Would the city have built those towers themselves? Would that have been an option that you would have explored at that time? Because my understanding is you get like $1 million a year off the rent from those towers. A little less, I think. Maybe you could be more specific.
Mr. Chairman, back to you, sir. We get $800 and some thousand a year for renting 18,800 acres for a couple of hundred windmills. I would love to think that we might have been able to do a project like that in partnership with our utility. I don't know the scale of that is pretty large. I'm not sure we'd have the capacity to do that, either through our bonding or our ability. But I think on some smaller cases we could. I think there's some opportunities for us to to do projects like this, create some local revenue that would help supplement our budgets.
Thank you. So large scale is not necessarily off the table. It's more, doesn't sound real manageable or real reachable, but there's nothing prohibited large scale. And large scale is kind of relevant right now because the new sources of demand are large scale, like data centers and things. So, and the demands on our western landscape are large scale now. So you're not prohibited from thinking large scale.
Mr. Chairman, as I read this, no.
Thank you. Interesting. Anybody else for this, or was there anybody else from WAM that wishes to speak? Thank you very much. Let's open up for public comment. Who wants to go first? Mr. Nelson, it's always a pleasure. Bring up your whole team. We know her. Hello, Mr. Nelson, welcome.
Good morning, Mr. Chairman. My name is Thor Nelson. I am an attorney with Holland and Hart. I'm here today on the behalf of the Wyoming Industrial Energy Consumers. Relative to this bill, I just want to say a couple of things. One is there is clearly an issue in Wyoming with making sure we have adequate levels of generation capacity in the state. And so anything that this body can do to promote additional generation being constructed, be it by municipalities or otherwise, is something that WIAC completely endorses. Having said that, and while we have no issue with the municipal's constructed generation, there is one issue that I do want to raise with the way that this bill is structured, and that is it could be read to exempt the contract itself from PSC review of the costs paid by the public utility to the municipality. And we do have a concern with that whatever that contract is before the utility gets cost recovery for it, that should be subject to the ordinary commission review of the costs that the utility incurs. And so if I might, to that end, I have a suggestion for the committee's consideration. On page 4 of the bill, on line 17, I would make 2 suggestions for your consideration. The first suggestion is, I think, mostly a clarification change. The way the bill reads right now, it says public utilities owned and operated by a municipality pursuant to an agreement. That's not quite right. The utility is not operated with an agreement. The utility is making a sale to the utility subject to the agreement. So I would recommend that you add the words between municipality and pursuant, selling electricity at wholesale. So it reads public utilities owned and operated by a municipality selling electricity at wholesale. Then it continues on, pursuant to an, I would make the an A and add the word commission regulated agreement in order to make it clear that there's nothing about this operation which denies the PSC jurisdiction over that wholesale purchase of electricity the way they have jurisdiction over all of the wholesale generations of electricity. That is arguably, I think, a simplistic fix, and it could be that more expansive language could be written to make that clear, but I was trying to edit this in the most limited way possible to make it clear that the commission is not being denied jurisdiction over the agreement, but that as to what the municipality is doing, that their side of the equation is not subject to commission regulation, just like all other municipal functions. Appreciate that and happy to stand for any questions.
Okay, thank you very much. Questions for Mr. Nelson? Questions for Mr. Nelson? Senator Scott.
Mr. Chairman, we're being asked with this bill to put the municipalities into the power generation business. That is creating additional government operating an industrial facility. Now, are the revenue bonds typically, because of the tax exemption for municipal things, would these revenue bonds be eligible for that? Are we essentially taking advantage of the tax subsidy the federal government can give for municipal bonds, or would these not be subject to that? And is it worth it to get the government involved in this to get that subsidy?
Mr. Nelson, I didn't know you were a tax attorney.
I'm not. However, I will say, within the limits of what I do know, Mr. Chairman, Senator Scott, in my experience, different electric generators bring to the table different advantages. Some of electric generators have advantages in terms of the way they can obtain financing. Some have advantages in terms of their technology, some in terms of their location, or just the way they do business. From my perspective, as a utility consumer, or representative of utility consumers, I want all of those options available for the utility to consider. And so while I don't know whether or not the municipalities in particular would be able to offer a competitive product to the utilities, I am all in favor of giving them that opportunity to compete with other suppliers of generation, because we have a serious need for generation here in Wyoming.
Mr. Nelson, if you were representing a group of, say, grocery consumers, and could you come and make the same argument for the municipality getting involved in grocery stores? Probably you could. You could, I know you could.
Mr. Chairman, I'll answer it this way. For a lot of reasons, the state of Wyoming, like most of the states in this country, have decided that there are special characteristics of electric generation, transmission, and distribution that warrant a different model than a regular competitive market. And so in that context, in a regulated monopoly environment that the state has decided we have for electricity, I think in that context, this sort of idea is a good thing. I think it is a very different question whether and the extent to which government should engage in what is otherwise competitive markets. And that's a different issue entirely. Some states choose to do that. We have states who, for example, lots of different states have state-regulated alcohol as a thing that happens. And, that's a separate question that I am not interested nor qualified in addressing.
Mr. Nelson, has electricity business gotten easier to navigate or harder to navigate in the past couple decades, from your experience?
Mr. Chairman, based on, I suppose, the amount of people who look to hire me, I'd say more complicated.
It's probably a good idea for you municipalities to get involved in this complex industry, don't you think?
Here's what I'll say about that, Mr. Chairman. I think that, in my experience, I've had the pleasure of working with a lot of different municipal utilities and in a lot of different contexts, and there are a lot of very smart, very capable people who work in municipal utilities and who make really good decisions about how they operate. Now, just like everything else, there are municipal utilities who don't do very well for whatever reason, but that's, in my experience, no different from any other sort of public utility that operates. And so from my perspective, having watched municipal utilities and watched the way they operate, I think there is every reason to suspect that they could be very competent, valuable participants in this energy sector, above and beyond just serving their own customers potentially and doing some arrangements with other utilities.
It'll be interesting. Everybody, when I first started out in electric business, it was very common for municipalities to participate in building nuclear power plants. And I worked for one called the Sacramento Municipal Utility District, and they had a kind of a rough encounter with reaching too far on their generation plants. And they weren't the only one. It was very common in those days. Anyway, it's always goes around, comes around. Any more questions for Mr. Nelson? Mr. Yen, Representative Yen.
Mr. Chairman, thank you. Maybe just a quick question for Josh on whether he sees any technical concerns with the amendment or if it looks okay.
Mr. Anderson?
Yeah, Mr. Chairman, yeah, I think the amendment seems to make sense to me.
Okay, thank you. Anything else from Mr. Nelson? Thank you, Mr. Nelson.
Thank you.
Who else would like to address the committee on this bill? Who else? Mr. Petrie. I think you're going to be the last one. Everybody's sitting on their hands back there. Mr. Burbridge, welcome. I think utilities like the idea of having more sources of supply, apparently. Mr. Petrie.
Thank you, Mr. Chairman. We didn't intend to speak to this bill, but I do want to
Hold that over, get it close.
I do want to agree with Mr. Nelson that unless it's your intent to make these arrangements that might come about between municipalities and utilities exempt from the normal prudence reviews that the commission conducts on all contract purchases of power, that you should make that clear.
Thank you very much. Did you tracked in his amendment and you would support that?
Yes, Mr. Chairman.
Thank you. Any questions for Mr. Petrie or Mr. Burbridge? Thank you. Who else, would anybody else like to address the committee? Okay, Mr. Bush is coming up and I see we have people online. We're going to get to all of them. Mr. Bush, welcome. Typically, we do the room first and then we go online. Mr. Bush, thank you.
Thank you, Mr. Chairman. David Bush with Black Hills Energy. Seeing that this is in our service territory from our mayor, I thought I probably ought to at least get up and try to offer a few comments. Originally, when the mayor approached us about this idea, there was some question about whether or not this was already possible. I know there's areas in Representative Yin's district, Lower Valley, City of Jackson has worked with them, or Town of Jackson, I guess, has worked with them on doing some power PPAs, power purchase agreements, and things like that. So we were under the assumption that this was already something that could be done. So there was some confusion from our team as to why we needed this. I still don't know that we're exactly there. There's still some internal debate happening on our side, frankly, on whether or not this is actually needed in order for them to do what they need to do. That being said, we're continuing to work with the city. We appreciate the relationship we have with the city and with the mayor and the city council. We work really well together on a lot of the data centers that are here now. A lot of that was a collaboration with them. So we're certainly willing to continue to work with them on some of these issues. There is with those data centers, there is a lot of misperception on what I think how those contracts and how those things work. So we have done a good job, in my opinion, working with the data centers to get these projects sited in Wyoming using a lot of the same processes that the data centers have used in other communities, where they're not really building generation to serve them. We're not building new wind power to serve them generally. We are purchasing that power from the market, and then it is provided to them. So there has been some concern, and Mr. Chairman, I'm maybe going off script a little bit here, but there has been some concern about the availability of power in Cheyenne with the new data centers coming here. And I can tell you that our team has worked very hard and to ensure that that's not a problem, that we will be able to adequately serve the rest of the customers in the city in our service territory. So with that caveat being said, I think it's with utilities wanting more power, potentially. It depends on the power, it depends on what kind of power it is, the rates and terms that come with it. I mean, it's a very, as you've pointed out several times now, this is a very complex industry, and it's well beyond just making widgets and selling widgets. We're in advanced markets. Mr. Nelson and others in his industry represent customers that are asking for very large loads and want very complex contracts in terms with those loads of electricity. So it continues to be an evolving market, one that we're working through the best that we can. Do we need more power at this point? I would say probably we'll always find a home for it. There's always a customer out there that might need it. But again, it depends on what that power is. Not everybody wants renewables. There are some people that still prefer thermal and want the reliability of coal and natural gas. 55% roughly of our system here in Cheyenne is coal generation. About 28% is natural gas. So we're still very much in that realm as well. So all that being said, Mr. Chairman, sorry I went off on a little bit of a soapbox there, or a tangent maybe. We're continuing to work with the city. We're happy if this does pass, if there's a way that we can work with them, we're happy to continue to work with them to try to find a path forward. But you know, at this point, there still is some internal debate on our side as to whether or not this is actually needed for them to do own and operate a wind or solar or whatever facility on municipal property, so.
And Mr. Bush, Senator Scott had asked a question earlier in the day about new generation for your utility, and we're going to talk to Rocky Mountain Power and others as well, as to whether that was by contract for, you know, purchasing the output of facilities or whether you were building your own. This municipal project would be a contract sold to you. You wouldn't own it. Is that kind of the trend that you're having with new power facilities, or is it a mix? And do you know what that mix is? To Senator Scott's earlier question.
Mr. Chairman, I'd say it's a mix. And it kind of depends on where you are too. So I represent Wyoming for Black Hills Energy, but I know in Colorado, we have seen a lot of changes in state law down there requiring the retirement of some of the thermal units and more renewables coming online because of the state mandate. So we are entering into PPAs with, word soup here, with IPPs, independent power producers.
PPA.
Sorry, power purchase agreement with independent power producers who, as Senator Scott was alluding to earlier, are independent private companies that build projects. We did just also enter into one here in Cheyenne. It was in the news. There was a company called Q-Cells. It's now owned by Southern Power. They built a solar farm south of Cheyenne that we are taking the power from and passing it through to some of the new data centers that are coming online. We don't own it, but we kind of move the power, for lack of a better term. So we are also always looking at opportunities if we need more power, what generation we might build, where it would go, what kind of power that would be, all that. We do work with the commission, obviously, on that as well. As a regulated utility, we can't just go out and build something. We have to have what's called a certificate for public convenience and necessity, which is basically the power or the Public Service Commission saying, yes, you need to build this. We agree that this is a prudent expenditure for serving your customers. So it's a mix. I don't have a percentage on it, but there's definitely a mix. But again, some of that depends on other states and other regulations and where they're going. So.
Okay, any questions for Mr. Bush? Representative Harrelson.
Thank you, Mr. Chairman. Mr. Bush, on the page 3, line 13, 14, as the good senator pointed out, the language that was stricken is within or without the state, and it's been replaced with on municipal property. Do you have any concerns? Do you see any concerns where that could affect other generational facilities in the state or could hedge in on other things? I'm not saying I see that, but I just want to make sure that we don't inadvertently create a problem for another generating facility.
Mr. Chairman.
Go ahead.
Representative Harrelson, I'll have to admit, I don't know, honestly, if that does cause a problem. That's not something that I had focused on with our team, but yeah, I would have to leave that to more learned folks in the industry. Sorry.
Anybody else? Senator Scott?
Mr. Chairman, my question is, does Black Hills see any special advantage to dealing with a municipality as opposed to some private generator? Is there something in the political or the economic situation that gives dealing with gives a municipality an advantage in this? And second, you've talked about some of the complexity of this. What kind of risks are we running? You know, municipalities are not generally in the electric business. They're in other businesses, and I'm wondering how well they might understand the risks if there's some pretty complex market risks that the power might not have a market.
Mr. Bush?
Mr. Chairman, Senator Scott, I'll take the second question first. I don't know what they would have to do there. I would assume they would have to, like many companies, including a lot of the data centers now, have experts in the electric markets field. Whether that's going out to the wholesale market and purchasing that power, construction, whatever they're looking at doing, they have to hire those experts. So I would assume the city would have to bring in some expertise, whether on contract or full-time employees to work through that. And of course, if there's a project, we would obviously work with them. We work with all of our customers on that and try to, if they don't understand, we help explain how our process works, how the state process works. We have a lot of outside investment that's coming in, so a lot of folks that don't understand Wyoming system. So we do work with our customers, and it would be the same in this situation with the city if they were to do something there. Your first question is a very delicate one. As the franchises that we operate under as utilities are granted by, basically, we negotiate with the city on those. So that's a complex issue that I'm not sure I want to get too far into.
He says he can't answer that, Senator Scott. For various reasons, apparently.
I think we have to answer that when we consider this bill.
Yes, indeed. Anybody else? Thank you, Mr. Bush. Well,
I
go
would
ahead,
say,
Mr. Bush.
Sorry, we do have a great relationship with the city, and I'm not trying to say that there's anything there. We do have a wonderful relationship with them. We work closely with the mayor and the city council's office, and we'll continue to do so as long as they allow us to, so.
Long and happy marriage. It's always true.
Exactly, Mr. Chair.
Thank you. Mr. Taylor, you're next, I think. Thank you, Mr. Bush. Welcome, Mr. Taylor.
Thank you, Mr. Chairman, members of the committee. Good to see you all again. Sean Taylor on behalf of Wyoming's Rural Electric Cooperatives. I hadn't really planned on saying anything today, but I did wear a tie just in case I felt compelled to do so.
Good thinking.
And on this particular bill, I might muddy the waters a little bit. First of all, I do want to say I appreciate Mayor Collins coming to my office a few months back before your last meeting and asking about the co-op's perspective on this bill. And I just want to draw one maybe distinction between what could happen with the city of Cheyenne and Black Hills and what happens out in co-op world. And you guys, we've talked about this before, but as you all know, our distribution co-ops have contracts with their wholesale power providers. That's Tri-State out of Colorado Basin, out of North Dakota, and Deseret out of Utah. So those are all requirements contracts with some stipulations. Tri-State is working on what they call bring your own resource, where this type of an agreement might be able to work. But short of that, if a municipality, and let me back up real quick, Mayor Collins and I did talk about our concern of this degrading certificated service territory, and he was cognizant to put that language in there that this could not happen without an agreement with the incumbent utility, or the utility of that certificated service territory, which is always our biggest concern, is protecting that certificated service territory. So if a municipality were to approach the local distribution cooperative to work on an arrangement like this, that distribution cooperative would have to bring in the generation and transmission cooperative, because that's their wholesale power provider, and that's who they are obligated to, and contractually obligated to get all their wholesale power from. So there would be another, utility if you were into the mix. It wouldn't just be between the municipality and the distribution cooperative. So I wanted to make that point first. And the second point, our hesitancy when I first talked with Mayor Collins, again, goes back to the degradation of our certificated service territory. So in this example, you would have a municipality contracting with somebody to come in and build generation and then sell that generation, be it wholesale, but they would sell that generation to the utility, so the utility would be the municipality's customer. So it'd be generating electricity and selling electricity to a customer, and would not be considered a public utility. The same thing is happening with the non-utility generators rule. It's not before the legislature, it's before the Public Service Commission, but that's the same thing. You would have a third party come in, build generation, generate electricity, sell that to a end-use customer, and not be considered a public utility. And that causes us a lot of concern, particularly as it pertains to our certificated service territory. So I just wanted to draw the distinction about the distribution and the relationship between the distribution co-ops and the G&Ts, generation and transmission co-ops, with regards to this bill, and take that opportunity to also say we are still extremely worried about what's happening to our certificated service territories and what that means to our end users, your constituents in rural Wyoming. Thank you, Mr. Chairman.
Questions for Mr. Taylor? Senator Landon?
So thank you, Mr. Chairman. You're right, Mr. Taylor, you did muddy the water a little bit for me. I just sitting here wondering if that limits the municipalities out there who can even take advantage of this bill. If, let's just say, for example, we are in High Plains territory up in the western part of the state, and one of those communities has an opportunity over the top of a landfill or whatever, and they want to try to accomplish something, does it play out this way? Would they sit down with High Plains and maybe be able to sell to that power co-op or the power generator that they've got a contract with? I'm trying to get, because it doesn't sound like there's very many co-ops that would really have an interest in buying any power from a municipality, because they already have that contract that you alluded to. Can you clarify that a little bit for me?
Yeah, Mr. Chairman.
So,
Mr. Taylor, go ahead.
Senator Landon, and I was thinking about this sitting at the back of the room, and that's exactly right. It could work out that the municipality would sell the electricity to a G&T. And if we're gonna use High Plains, that would be Tri-State. And then Tri-State would sell that back to High Plains. I don't know why I don't know why you would wanna do that, other than to maybe help your municipality out with economic development. And that might be an option, but you're kind of creating a middleman where there doesn't need to be a middleman because of our wholesale power contracts. But again, Tri-State in particular is working on what we call bring your own resource, which would allow a distribution co-op to go outside of that wholesale power contract and look for other opportunities, whether or not it would have to pencil out for ultimately the end consumer, whether it made sense to do that or not.
Anybody else? Mr. Taylor, do you think these could be PURPA facilities, meaning that's a specific federal law that allowed for builders of renewables up to a certain size to actually make sure that the utility does buy the power. They have to buy it. And are you guys covered by PURPA?
Mr. Chairman, we are, and we would hope that this would not would fall under PURPA. I don't know that it wouldn't.
I don't see in the proposed law where it would not necessarily be.
Maybe because it's a municipality that's building it and not a private
don't know.
individual? I don't know. That's a good question.
Yeah. And then, so, Mr. Taylor, if you forgive me, if we take, we've had a high-level discussion with the cooperative community about territorial integrity for several years now. It has sort of involved the placement of a large load within the territory, closely to, within the service territory, and the boundary between cooperative utilities and investor-owned utilities has been, you know, those large loads come in and they say, well, you can't serve me, so I want this other person to serve that's close by. Or, you know, and there's various ways that plays out, and the commission is trying to deal with that now. Could this create the exact same thing, only instead of with loads, it's with generation sources, and especially where they're putting the power to you, for example, and what if you can't take it, then can they go to the adjacent utility? Is it kind of the mirror of the same problem potentially?
Mr. Chairman, I think you're spot on. It's a slippery slope, which is, in the conversation I had with Mayor Collins, that's our biggest concern. We do feel comfortable with the language in there that says it has to be, you know, there has to be an agreement. But if you don't reach an agreement and this municipality still wants to do this, what's to keep them from coming back and having a third party, you know, non-utility generator do the same thing for the municipality? So I think you're right on that this could mirror, or it might mirror the same concerns that we have. Right now, the saving grace is there has to be an agreement with the incumbent utility for this, under this proposed bill, to move forward.
So that's not a lot of comfort for me, Mr. Taylor, because if it's a PURPA facility, I don't think it matters whether the agreement is. And if there's some federal part of the law that says the PURPA doesn't apply to municipalities, which I'm not aware of, but it doesn't make sense to me. But if there was, then they could just do it by contractual basis and achieve the PURPA status, enforce it. And we haven't changed that in Wyoming. They could still do that.
Mr. Chairman, I don't disagree with you, and I'm not a PURPA expert, nor am I an attorney, but I would think there would have to be some consideration, if it were a PURPA facility, that the distribution co-op, if they were forced to buy that PURPA power, if you will, then that would be a contractual, they would be breaking their contract with their wholesale power providers. There would have to be some consideration of that relationship between the wholesale G&T and the distribution cooperative, if it is a PURPA facility, considered a PURPA facility.
And PURPA is an acronym. It's a federal law that requires utilities to purchase renewable power at particular levels of rates. So it's interesting. There's lots to talk about there. Any other questions for Mr. Taylor? Thank you, Mr. Taylor. Who else would like to address the committee on this? I know we've got one online. I'm looking around the room. I'm looking who's, you know, in church we have this thing, forgive me for what I've done and for what I've not done. There's lots of not dones in the back row that are sitting on their hands, I might add. Let's go online. Who's the gentleman that would like to address us from online? Mr. Cole from Gillette, welcome. We are muted, sir. You ought to be able to get unmuted. We see you fine. We can see the red mute button on your caption. I'm sorry. Keep working at it. Can anybody help him tech-wise? Is it in the bottom of your screen with, you can put it on your cursor? We'll keep working on it. We'll move on. Please interrupt us when you get unmuted, okay? Any further discussion, anybody else? I would like to have the gentleman be able to give his testimony. Somehow, sir, I'm sorry, maybe there's probably a way you could call in with your phone. Is there a way? I know you're trying hard, and it's probably very frustrating. All right, we're going to go ahead and keep working this bill. And then if you get freed up, sir, we'll try to work you in. Thank you very much. Committee, we've heard most of the public testimony. There's still some trying to happen. Do we have anything else on it? Josh, I'm going to go to you first.
Mr. Chairman, just a real quick clarification. I spoke with Mayor Collins, and their proposed amendment, they had recommend deletion of the wrong section, I believe. So instead of deleting page 2, lines 20 through 23 and 1 through 3, they're instead, I believe, proposing to delete page 3, lines 8 through 23, and page 4, lines 1 and 2. And then replace that with the new subsection 3 on page 4 after line 2.
Okay. Is it still going to be a C?
It would still be a C.
Okay. So the same language, it's just how it's inserted instead of page 2, lines 20 through 23, and page 3, lines 1 through 3. It's not that. It's page 3, lines 8 through 23, and page 4, lines 1 and 2. Is that correct? We don't actually have a motion. This is just to clarify what we've all been handed. So committee, I think, seeing no further public testimony. Oh, okay, Mr. Kolb, did you get on with the phone? Go ahead. We want this to work for you, Mr. Kolb. Can you see him, Katie? There he is. Can you hear him on the phone? Mr. Kolb, you need to push *6 on the phone. Looks like it's
Okay, great.
Say that again, Katie. What do we need to do?
Sorry. I'm sorry about that.
you
This
need to
is
mute
Mike
your-
Cool. Can you hear me?
Yes, I think so. Let's try it. Go ahead, Mr. Kolb.
Mr. Chairman, I apologize. I am on the phone now and have logged off of the webinar. I am the city administrator for the city of Gillette. I'll make it very brief. I do support Mayor Collins and WAM's efforts for this bill. I want to just recognize the amendment that was discussed by Mayor Collins this morning regarding changes to Section 15-7-111 regarding bonds for municipal development. It's my understanding an amendment will be proposed to create a new section that will incorporate the changes that are currently in the draft legislation. There's just as discussed during the testimony today, there's some concerns with Gillette regarding only allowing generation facilities on municipal property. As a municipal electric provider, we do own generation facilities outside the city of Gillette that are not on municipal property that we have bonded and financed for. So I do believe that the amendment that was discussed by Mayor Collins is appropriate, and we do indeed support this draft bill. And I'll stand for questions if you have any.
Thank you very much. Any questions for Mr. Kolb? Senator Barlow says hello. Representative Knapp says hello. Okay. Thank you, sir. Thank you very much. We're back, I think.
Thank you, and I apologize for the technical. Thank you.
Thank you very much. Seeing no further testimony, committee, you've heard testimony. What is your pleasure? You've heard the testimony. What is your pleasure?
Move the bill.
I heard a mumble-like voice from.
Mr. Chairman, Representative Yin moves the bill.
Thank you. Is there a second? Second by Barlow. Discussion. Who wants to start? Let's start with Senator Land and then Senator Scott.
Mr. Chairman, I'm going to support this bill. And I agree with you. I think it's going to drive some future debate and considerations from a policy standpoint. But I think it's worth the effort. It wasn't that long ago, I was driving past a pretty sizable landfill there in our community. And I just found myself wondering, what happens to this piece of land going forward? Nothing at this point, but something like this is intriguing to me that I think is kind of worth pushing the boundary a little bit and seeing how it might work. I'm a little bit concerned on the co-op front, but I think we can cross some bridges later that, and maybe get things resolved as we go. But I kind of like what this bill does.
Thank you, Mr. Chairman. That landfill, is that the one where all those wind turbine blades are in Castle? They're in there somewhere. Senator Scott.
Mr. Chairman, I do think the amendments, the city, revised amendment that the city has will eliminate the problem I saw ahead of time with this bill. Mr. Chairman, the reservation I have about this bill is that this is public ownership of the means of production, which is the classic academic definition of socialism. And I've been looking to see if there were special circumstances that justify doing that in this particular case. And electricity has some funny characteristics. I haven't found those, Mr. Chairman. I have heard quite a bit about, and we may learn in the next two segments in this meeting, Mr. Chairman, some more, about the complexity and the needs in this area. But, Mr. Chairman, I would have to say at this point, I'm going to vote no on the bill because it is classic socialism, and I haven't found an additional justification for it. There may be such. I would be open to being convinced later on a private bill, but at this point, I have difficulties with it because I don't think there's any special advantage to having a city own and operate a municipal utility generation facility that could well be done privately.
Thank you, Senator. Well, we've had the great speeches from the senators. We should work the bill and get some amendments. So are there any proposed amendments? Senator Barlow.
Thank you, Mr. Chairman. I think I'm going to propose the amendment was provided by the Mayor Collins, and I want actually, maybe since Josh has actually spoken with Mayor Collins about how it actually is placed in the bill, I'd like him just to walk through the bill page by page, and so we understand exactly the understanding he has now with Mr. Collins. I think I understand it, but I just soon them walk through this
You want
amendment.
Josh to do that? Josh, can you do that?
If Josh doesn't mind, just
We can get
page
from
by
right there,
page in the
Josh,
bill.
if you wish.
I think you were going to start on page 2, line 20, and then go from there. I think everything, prior to that, everything stays the same, but page 2, line 20.
Wherever you're comfortable, Josh.
So, Mr. Chairman, and I would defer to Mayor Collins if I'm misunderstanding, but I believe that instead of the deletion, there would not be a deletion on page 2, line 20. That would stay as it is in the bill. Page 2, lines 20 through 23 would stay the same, as would page 3, lines 1 through 3. The change would be on page 3, lines 8 through 23. That would all be deleted, as well as page 4, lines 1 and 2. And then after line 2, that new subsection C would be inserted as in the suggested language from Mayor Collins.
Is that your understanding, Senator?
Thank you. Thank you
And I
for
don't recall,
clarification.
did we get a second on his amendment?
I'll second the motion.
We got it from Nat, so discussion? Discussion? All those in favor signify by saying aye.
Aye.
Any opposed? That amendment is carried. There was an amendment offered earlier by Mr. Nelson. Would anybody care to take that up? We've got a motion by Landon on that amendment. Is there a second? Second by Newsom.
Mr. Chairman, if I could we make sure that Josh, that's being actually put into the new amended language that I don't know that Mr. Nelson had privy to. So Josh, do you understand where that would go in this new subsection C? Thank you, Mr. Chairman, just to clarify.
Just to make
Thank
sure
you.
we track it, yeah.
Mr. Nelson, would you mind helping us out to make sure we got it in the right place? Come on up. And Mr. Anderson, you go ahead.
Sorry, Mr. Chairman, I was discussing with Mayor Collins at the time, so I think I missed the motion.
I think we're picking up the theme that Mr. Nelson produced earlier.
Okay.
Senator Barlow was concerned that it involved the very amendment we just made.
Mr. Chairman, it would be the language would be unaffected by the previous amendment.
Mr. Nelson agrees.
That was my understanding. I don't think the amendment, as I understood it, is affecting the same language.
It's different places.
Yes.
Thank you very much. Okay. Do we have the amendment from Mr. Nelson? Do you have it in good shape?
Yes, sir, Mr. Chairman.
Okay, do you want to give it a high level?
So, Mr. Chairman, it'll be on page 4, starting at line 17, but in context, it would say, public utilities owned and operated by a municipality, and then we'd add the phrase, selling electricity at wholesale pursuant to, and then we'd strike and insert a commission-regulated agreement with a public utility as provided in that section.
Okay. And we had a motion and a second. Is it understanding that this would exclude PURPA, which could be put, a PURPA-type project could be put, wouldn't have these restrictions? Oh, sure, Mr. Nelson. It's all back to your amendment. What if it was a PURPA project and there was no contract? Go ahead.
Mr. Chairman, in response to your question, a PURPA contract still has regulation by the Wyoming Public Service Commission insofar as the Wyoming Public Service Commission sets the avoided cost rate. And so to the extent the project sought PURPA qualification, which I think it theoretically could, the commission would retain jurisdiction over the rate paid by the utility to the municipality under a different standard instead of the just and reasonable standard for all other PPAs.
The avoided cost standard.
It'd be an avoided cost standard in lieu of that, but the commission would still have the ability to determine whether the rate was reasonable.
Thank you. Commission, you agree? You can just nod. Got nods from the commission. Thank you, Mr. Nelson. Okay, back on the amendment. Any further discussion? All those in favor signify by saying aye. Aye. Any opposed? Anything else on the bill? Anything else on the bill? Would we call roll on the bill, please?
Mr. Chairman, this is roll call for 25 LSO 0027, electricity production facilities on municipal property as amended. Senator Barlow?
Aye.
Senator Boner?
Aye.
Senator Landon?
Aye.
Senator Scott?
No.
Representative Chadwick?
Aye.
Representative Haroldson?
No.
Representative Harshman?
Aye.
Representative Knapp?
No.
Representative Newsom? Representative Ottman? No. Representative Wiley?
Aye.
Representative Yin?
Aye.
Co-Chairman Olson?
Aye.
Chairman Case?
No.
9 aye, 5 no.
Okay, that amendment is carried. Let's take a short break. Let's come back at, well, I know that you won't do short, so let's come back at 10:35. And we'll begin with our presentations from our investor-owned utilities on proposed legislation, taking utility cost recovery as the first bill up. Is that okay? You guys get set up? All right, till 10:35. Your name again, please. I got the first one.
Oh, there we go. Nikki Kablia.
Kablia.
Kablia, yeah.
All right.
Yeah,
Thank
Tom
you.
kept asking me that too. How do you say it? It's always wrong. It's fine. No worries.
Well, thank you, Ms. Kablia. We're glad to have you, and the floor is yours.
All right, so if everybody has, hopefully in front of them, the securitization overview that we had provided, just wanted to provide a little bit of information as to what we're talking about when we talk about securitization. Really, as you look at what we're seeking to do is have the ability to get some cash perhaps sooner than the company would have recovered under normal rate making. So think of maybe some examples I put in here were asset-backed securities or mortgage-backed securities. So car dealers who have a financing arm oftentimes want to sell all of those loans that they make to the consumer so they can get the cash today to go out and buy new cars. That's kind of the concept we're talking about here. Securitization, looking for costs that the company has already incurred, that we will go through a process with the commission. The costs will be deemed to be prudent, and we want to actually get the cash recovered sooner than what we might have otherwise recovered it over if it would have been over 10 years. So it's really kind of a cash play, is to get cash upfront. In order to do this, it actually needs legislation, and there's several states across the country who have this legislation, because for rating purposes, the investor community and those who would actually put their money into this want to make sure that the cash is going to be there from the bills from our customers, that they're going to get their money back for, in essence, loaning the funds to Pacific Corp. So that's where the whole concept of an irrevocable charge comes in. So I've used those words here, and it's the bill that would give that right to that irrevocable charge, so that it's dedicated out there. There's no future proceeding that could change that collection. So that provides that guarantee to those bondholders that the money's coming back to them. Ultimately, Pacific Corp would get the cash, or the utility would get the cash, but the customer bills, when the money comes from the customers, it funnels through an entity that makes its way back to the bondholders. So think of, if you're an investor, you're getting your principal and your interest at some point, your return. So we're serving as the conduit for that at the end of the day. And as I noted, this is for prudent costs that we've already gone through some sort of proceeding with the commission to say that, yes, those are recoverable. They could be extraordinary one-time items. If you look at examples of where other utilities have used this, storm damage. So in Missouri, there was one here back in February where they used it for, if you remember Winter Storm Uri, if you ever heard that storm in Missouri, they actually recovered $311 million of securitized bonds that they used to pay for the fact that they had all the storm damage from that winter storm. In California, they use it a lot. Both Portland General, or if I can say Portland, Pacific Gas and Electric and SoCal Edison have used it for wildfire mitigation costs. And PG&E also did use it for some wildfire claims, but really all like the vegetation management and other costs that are part of projects to shore up the system for wildfire. So those are kind of some examples of where people have used it before.
We're going to the next slide.
Yep, yeah, I was just gonna say, turn to the next one.
Can I ask a preliminary question before you? So, Ms. Kablia, could you help the committee and maybe the audience to understand how running a utility has gotten more difficult, and why perhaps raising capital is more difficult than the traditional utility model? Not that it was ever easy, but it has evolved to a new level, hence you're proposing new tools. Could you maybe talk about that evolution, just a little bit of stage setting before you do this next slide?
Sure, yes, thank you, Mr. Chair. So over the years, the challenge has been about what are utility ratings looking like, and are bond investors going to want to fund our operations? So traditional path has been, we go to either equity investors, which we're in a unique situation because we're not publicly traded. We have Mr. Buffett as our sole owner, but we do go to the debt investor community, and we're looking for people who want a highly rated utility. They're willing to invest in us. As we see more challenges with lowering ratings or lowering metric for the utility company, those bond investors might not be interested in supporting the utility any longer. So we're looking for other tools and perhaps other populations of investors who can help fund the operations. And the operations are getting more complicated because, as we know, we have all these different laws in various states around, renewables, or, revisiting our coal fleet and CCUS, and, all those things make it a lot more challenging for us to figure out where are the funds going to come from besides just our normal cash from operations that we get from, customers and rates. We typically have an appetite beyond just what we get in customer rates for those big capital projects, and that's where the complication has come. And so we're looking for another tool that will enable us to get cash that we can use for, funding the business and keep us running. So that helps.
Thank you. Representative Ottman.
Thank you, Mr. Chairman. Just a question, and you may be going to cover this, so forgive me if I've jumped the gun. But what I'm wondering, with these bond investors, what kind of voice are they going to have in the running of the utility? And they're going to have a vested interest, so how is that going to work?
Ms. Kabuya.
Yes, thank you, Mr. Chair and Representative Ottman.
And just between you and me, I hate the word chair.
Okay, sorry.
If you wouldn't mind doing chairman, and when Katie gets to be chairman of this, you can call her
She can
Madam
do-
Chairwoman or whatever
do
she
whatever
prefers. Yeah,
Thank you for the clarification.
Thank you.
So those bond investors don't have any say in the company. In this particular securitization structure, they are a remote entity who put up the funding, and they'll be working with the banks and various parties to get their cash back. So they don't have the opportunity to vote on anything, or they won't have any influence with the company. It's just almost like if you're an investor in a mutual fund. Maybe you'll see proxy statements, but in this case, you wouldn't. You're just out there, you have money, you have a return coming to you, but you really don't have any say in how the operation is running.
You would have some rights under default, which could be operationalized, but not normally. They wouldn't have any rights. Yeah, thank you.
So can I continue?
Yes, you can.
All right, next.
We're
the
kind of
next-
like this in Wyoming. I apologize. We're glad you're here.
No problem. So the next slide talks about who's involved. So as I mentioned, the legislature, you're passing the law. That's step number one. And then if we move through the process, the utility ultimately will file a financing order with the commission. There's going to be lots of folks hired. There will be lawyers and underwriters and consultants. We ultimately need to set up what's called a special purpose entity. And that's where the entity where we pass the funds through from customers, and then it goes back to the bondholders. The commission ultimately approves that financing order, and they also could hire consultants as they see fit. And all the consultant costs become part of the costs that would get wrapped into the bond and get recovered as part of the monthly payment that would come from customers. It has to be, as I mentioned, non-bypassable, and it has to be something that gets trued up periodically, because the intent is to make sure that there's enough funds coming from that customer rate to make sure those bondholders are made whole at the ultimate termination of those bonds. The next thing here talks about what securitization is not. It's not intended to replace our current regulatory process. As I mentioned, any costs that are securitized would have already been through some sort of proceeding with the commission to deem that they are prudent costs. It's not a tool that's used to fund other large capital investments. We would still use our traditional financing that I mentioned, the bond, the mortgage. We have a mortgage going out to those types of bondholders. That's typically how we fund our large capital investment. So that process is still going to continue. This is really for those unique one-time costs where we would have gotten recovery, but perhaps over a longer period of time, and having the cash up front would be useful, because in essence, we've probably already incurred that cost and we're trying to get that cash back. So as I note here, we don't want it to, the cash is helpful so that we don't have to utilize all of our other bond capacity for ongoing operations. It's great to be able to, if we have a dollar out the door, that we can get the dollar in sooner so that our normal operating costs are covered with this type of a unusual or a unique cash flow. And it's not intended to generate income for the utility. The costs that we would have in terms of the rate associated with those bonds would be collected from customers and passed through to the bondholders. There's nothing that results in earnings for the company. You know, I think earlier there was a discussion about the earnings or the return for utility. This isn't in that bucket where it's not intended to make us money.
Keep going.
Then I'll go to the next slide. So in terms of benefits, part of the proceedings or the financing order should typically demonstrate the benefits that customers would realize. The comparison is often the bond rate that you could get from these types of bonds, which would be AAA rated. Because of that certainty that the money will be coming from the customers, the rating agencies give that, government status, AAA rating. There's still a spread put on that because it's sort of the risk around the market itself isn't as mature as a bond mortgage market. So there's a spread. So the cost, though, however, as I noted here as an example, today that would be a 4.7% interest rate compared to our weighted average cost of capital, which is 8.625. And that weighted average cost of capital is a combination of the debt and the equity that the company has on the books. And that's what we earn, in essence, on other items that are rate-based. So that's the benefit, is the differential between those two costs. And then I provided an example just to do some math here, right? If you had $100 million using those two rates, the carrying charge is $26 million versus $49 million for that type of investment at that level. And then in terms of the benefit for us, I've noted you're providing us cash up front for something that we had perhaps collected over many years, and that the ability to use the cash from those bonds for our ongoing operations and have the bond capacity that we have in our mortgage to do the big capital projects that we're pursuing in our plans. I will stop there.
Any questions for Ms. Cablia?
Mr. Chairman.
Representative Yan?
Thank you, Mr. Chairman, Ms. Goblia. Thank you. I think the slides are useful. I have a lot of questions. What are the risks? Well, what kind of assets are you thinking of bundling in these sort of securities? And then two, what are the risks, and is there a risk of speculation that caused other crises with, like mortgage-backed securities, for example, that you wouldn't see in this sort of securitization?
Ms. Cablia?
So, Mr. Chairman and Representative, at this point, I wouldn't say there's this cost that's top of mind that I'd want to securitize. It's the examples that we noted, the wildfire mitigation plans, or if there's a one-time storm that comes through that has a significant impact to the company. There are other states that have approved energy costs. So if you think of our power cost mechanisms that we talked about, that the bill allows recovery of those types of costs that we would be collecting through the mechanisms. I think you discussed those mechanisms earlier. I wouldn't say that there's any risk similar to the asset-backed securities or the mortgage issues that have happened because of the connection it has to the law and the collection from customers and the true-up that happens every period. And these aren't the homes and the cars that we're backing. It's real more intangible type costs that we're securitizing, which is linked to then customer rate recovery.
Anybody else? Senator Scott?
Mr. Chairman, there's an awful lot I don't understand about what's going on with this. But you were talking about getting a 4.7%
Cost of capital?
Interest rate on these bonds?
Yep.
What's special about these bonds that would get that kind of a rate? I would think it would be a good deal higher.
Ms. Cablia?
Yes, Mr. Chairman and Senator Scott, the linkage there is that the guarantee that's coming from the law that the money will be provided back to those bondholders through the customer rates. Therefore, the rating agency sees that as virtually certain and give it that government AAA rating. And you can compare that to our utility rating is not that high. As an issuer, we're double B plus or triple B plus would be our issuer rating.
So
it's just a different.
Just by way of background, if they issue a bond now, it's triple B plus is their rating. And what is the cost, would that be roughly?
Right now, we're between 5.5% and 6%.
Okay, so it's when they're comparing it, Senator Scott, to the 8.625%, that's their weighted cost of capital. That's the cost of equity and their debt in their portfolio. So it's higher than their debt. So debt's lower cost than equity. And this sort of takes advantage of that one step further by moving it out of that BBB plus class of equity and allows them to seek AA or better rating, I suppose, on the issuance. Would that be fair? Do I have that right?
Correct, it will have the AAA rating of the
Okay.
government rating, and it still has a credit spread to it, so it's not a perfect whatever treasuries are type of rating, but it's better than what the utility has on its own.
And it could achieve that higher government, the same rating as government because of the function of being a regulated utility? And in essence, its bondholders get a preference? Or does it achieve it because there's other guarantees that you haven't mentioned yet, like the state actually guaranteeing these bonds?
No, Mr. Chairman, no, there's no other state guarantee or issuance. The guarantee is the recovery in rates that cannot be bypassed. That's what gives it the very strong rating, is that certainty that the cash will be there in the future to protect those bondholders.
And in essence, if this is helpful, you guys, would we be binding future commissions and policies with respect to this program?
So, Mr. Chairman, the only thing that would be binding is this particular order, and the original costs that we said were prudent. There cannot be any change to that once it's established through the financing order. So that the ongoing rate from customers has to be there, plus the true-up, and it'll again be associated with the certain population of costs that would be subject to the specific financing order that we would come in and seek. We want to securitize these costs.
We okay? Representative Ottman.
Thank you, Mr. Chairman. And again, it's just because this is so new. But for instance, if there is a location such as our southeast right now where utilities are gone, businesses are gone, customers are gone. So in that case, there really couldn't be a customer guarantee because they're not going to be paying anything. They don't have anything, and that would be capital construction. So where would those payments be made from? What, from the rest of the customers in that network, or how would something like that work? Because we're seeing that, and we're going to deal with it.
Ms. Caplia.
Yes, Mr. Chairman, thank you, and Representative.
Maybe pull that mic closer.
Oh, sure, sorry.
Yeah.
I'll stop turning my head too. I'm trying
Yeah,
to look around. So in terms of, I hear you with what happens as customers are declining, and that's where the true-up process would come. Right now, Pacific Corp, does have a series of customers in Wyoming, and unfortunately, if there's a population that moves or something is lost, then that true-up would put the burden on the remaining customers to ensure that the funds still come and are available for those bondholders.
Anybody else? Just before we move on, can you give an idea, because your company's been in for 2 rate increases now, we're seeing the second one, they're pretty sizable. They've had some power cost flow-throughs that are sizable. It comes on a period of time when your utility actually guaranteed a rate freeze. I don't know if we actually called it that, but basically there were several years when Rocky Mountain Power and Pacific Corp didn't come in for a rate increase. And so that world has changed, obviously. And we all see that. And there's a lot of investment required for the system now that was not on the table a few, in previous times. And we've moved from an era where our biggest power plants we were building was the changing of light bulbs throughout our country. It freed up an enormous amount of electrical capacity. We've moved past that now to where new demands are sizable, gigantic really, prevalent, and fill up our windshield for what we think the future is going to look like. and the company's searching for financing tools to make it affordable to continue to invest in this environment. Whereas if the traditional tools, the rates keep going up and will get more expensive for customers. So I think what you're saying is we're trying to find a win-win to be able to achieve investment objectives with protecting ratepayers at the same time. Now, I know I'm putting words out there, but I'm trying to reach a common denominator here with our understanding. Would that be fair? And if it's not fair, tear me up.
Yeah, Mr. Chairman, thank you for that. I'd say it's fair that we are looking for other tools that could help with cash flow and financing the business to do what we can to keep customer rates low, because you are correct, we have all these pressures out there with requirements and capital, and we've got some other, financial challenges that, I'm sure everyone is generally aware of what's happened with fires in the Pacific Northwest. So that's what we're looking for is ways to keep the cash flow and rates low.
Anybody else? What, are you going to address this too?
Chairman Case, I think Ms. Coblia covered it. I mean, I have nothing further to add to how she answered the question.
Mr. Carter, do you have anything? Do you want to talk about our bill, or do you want to do that?
Sure, we're happy to walk through kind of the bill.
Okay.
And really, the bill does exactly what Ms. Coblia talked about. It empowers the commission, empowers the company to go to the commission to do exactly what we talked about. And I don't know if I need to, I think we covered it. I mean, the goal here is to provide the tool necessary as a regulated utility. As you know, we joke that everything is regulated except for where we park and where we go to the bathroom, right? And so we want to, we can't just do something like this on our own. We have to work through the commission process. And so the legislation does that. The legislation allows for a financing order process, and then protects that process and ensures that this tool is then available if necessary for investor-owned utilities. And so Pacific Corp wouldn't be the only.
1 second, Mr. Carter. So just for everybody's edification, it's on your online version, it's on the website, everybody in TV land. But the immediate bill afterward was called large loads, and we're setting that aside for a minute. We're going to do that one next. And so it is Bill Draft 25 LSO 0314, Working Draft .4, Utility Cost Recovery Bonding. And it's on your electronic packets on page 42. So, Mr. Carter, back to you.
Yeah, I think that I don't have much more to add than, as I was saying, this is not only a tool for Pacific Corp. This would be a tool for any investor-owned utility. And I think, to Ms. Coblia's point, all utilities are looking for new tools, right? We've been talking in the Minerals Committee about new tools as it relates to wildfire risk, wildfire mitigation. This is an additional tool to Chairman Case's point earlier in the day, to allow for strong utilities, which then allows for economic development and growth. And so that's, I think, what this bill does. It puts the process in place to allow an investor-owned utility to move towards securitization.
And did you have, within the draft bill, there's a staff comment. I think this came from you, Mr. Anderson. It's on page 8 at the bottom, and it goes over into page 9. And the gist of it is that the legislation suggests that the financing order is binding on the Public Service Commission and their rate practices, but it doesn't say specifically it's binding on the utility, which is kind of an obvious thing. So can you react to that staff comment? We have a very smart staff. They're like the best.
Yeah, so, Mr.
Go
Chairman.
ahead.
I think the only question that I have, and I don't know the answer to it, is how the rating agencies would react with wording around binding on the utility. So we end up, the utility will set up a special purpose entity that's supposed to be bankruptcy remote, and basically it's then takes the utility out of the equation other than we're funneling the fund. So I would just need to see, hey, rating agencies or banks, do you have a view on this language, just so we can understand if that would change the AAA rating that we were seeking through this. I just don't have the answer to that.
Fair enough.
And then I think, Mr. Chairman, we do, on page 9, lines 26 through 28, we would recommend a change here, and
You might have a different version. Ours ends on line 26.
okay,
Page 9.
I will look for a.
Sometimes the formatting gets just slightly off. It ends with, this paragraph shall in no way preclude bond guarantees or enhancements under this section.
Yeah, I think we're, and I don't know, Ms. Kalia, if you want to comment on this one, this sentence here. You got a concern there.
Ms. Cablia.
Thank you, Mr. Chairman. So I think it's the same. It's the language that talks about the bondholder's sole recourse for the default shall go against the issuing utility or its assignee. So that has that same language of just needing to understand, since it'll be a special purpose entity and not the utility that's ultimately required to, make those bondholders whole. I'd want clarity around what would that mean to the rating agencies and their ability to give it a AAA rating with that language.
Yeah, it seems to me that if you were buying the bonds, if your recourse was only, you would look to the special purpose agency, but that may not be enough to give you confidence about a AAA rating. You may want to look farther, but that's the way it would go.
Yeah, Mr. Chairman, that's the question that I would need to clarify, is just around it's really the customer rates. It's that funding that's giving them that protection. And so how does the utility, since we're just the conduit, support the rating?
It's customer base through our umbrella of regulated utilities enforcement.
Right.
To do that, yes. Senator Scott. I'm sorry, I passed over Senator Landon. Can we do you first? Sorry.
No problem, Mr. Chairman,
take care of
thank
my
you.
senators.
I just wanted to follow up on the chairman's question regarding what essentially binds the Public Service Commission. Can you envision a time where you would need to or want to modify such a securitization? Can you think of that? Because that's the caution. Why would it be binding to the commission but not so binding to a utility company?
Who's next? Ms. Kaplia.
Yeah, thank you, Mr. Chairman and Senator Landon. The order itself, the financing order, I don't envision that ever changing. It would be linked to a certain set of costs that we sought to get recovered and then securitized. Therefore, I don't see that there's any future costs associated with that or any need to change it. And that's, I believe, what is the linkage, again, back to that AAA rating, is that guarantee. It's never going to change. It'll be out there for whatever the duration is, and that duration will be driven off of the tenor of the bonds. Is it a 10-year bond? Is it 15? Is it 30? That's the time period where we're I guess committing to all these bondholders. The funds will be available.
Senator Scott.
Mr. Chairman, I've got a question on page 9, starting at line 23. And let me preface my remarks by saying that, I haven't had time to read the bill. I just got it just as we started this meeting, and I was unable to quite read your presentation. My eyes aren't good enough to see the fine print on the screen from this position, so I'm a little bit of a loss on this bill. But it says bondholder's sole recourse for default should be against issuing utilities or its assignee. Mr. Chairman, the question is that deceptive language? Because it sounds to me, from what I've heard, in the presentation so far that the real recourse is against not the state or anybody like that, but the people who have the misfortune to be your ratepayers. And so, yeah, it's against the utility, but they promptly pass the cost on, and it's really the ratepayers that get hit. So this language strikes me as deceptive. Like, maybe I don't understand the language at all.
It's a fair observation. Ms. Cablia.
Yeah, thank you, Mr. Chairman, and thank you, Senator. That is the specific sentence that I'm concerned about relative to what the rating agencies will take from that. I'll say my preference is that sentence would not be in the bill, because I think we're back to it's the financing order that's the binding, and you're correct, it is then ultimately rates from, you know, customers that feeds into the bondholder at the end of the day.
I think you closely have the same concern, actually. You look at it. Anything else, Senator Scott?
Mr. Chairman, I don't understand the rest of the bill.
Yeah, and
That's quite-
just understand, this is kind of using our discussion moments. But it's a really important concept if we go forward. Senator Yen.
I'm not a
Representative
senator,
Yen.
and I have no intention to be anytime soon. Thank you, Mr. Chairman. Ms. Koblia, again, multiple questions. This one is, does this legislation need to be passed in every state that you have territory in, or just the one where you intend to securitize a specific asset? Or so, for example, does our Public Service Commission need this legislation for you to securitize the wildfire mitigation plan in another state?
Go ahead, Ms. Kabli.
Thank you, Mr. Chairman. Yes, Representative, at this point, the cost that we would securitize would be specific to a cost that was allocated to Wyoming customers. So it's not intended to be an allocation of Oregon costs. So in order to have this tool for Wyoming's share of whatever it might be, let's say there's some big storm that comes through, that would be the tool for us to securitize it. As the legislation in Wyoming enables us to do that, and it goes then through Wyoming customers and through, of course, the commission here as well.
Go ahead.
Mr. Chairman, if the multi-state protocol expires, does that change, or how is the cost allocation? I mean, I guess this is a very complicated question, but would that affect the cost allocation for something like a wildfire mitigation plan?
Ms. Kabli.
Yeah, thank you, Mr. Chairman. Yeah, Representative, yeah, the cost allocation is definitely a challenging question, but anything under the securitization would only be intended to cover costs that we ultimately deem to be recoverable for Wyoming customers.
And Ms. Kabli, and just tag on, wouldn't that be the commission's requirement too? I mean, they're not going to authorize a plan for securitization unless it exhibits benefit to Wyoming customers and is prudent, I would assume. I mean, I'm assuming all the same standards would apply.
Mr. Chairman, I assume the same thing, that
Yeah.
the commission is deeming the prudency of the costs that are allocated to Wyoming using whatever the appropriate allocation methodology is at the time that we were to seek securitization.
And so as I hear it, it's not to bring in any type of new costs or somehow sneak costs into the Wyoming jurisdiction. This is still the same costs that we're talking about that our ratepayers have to face no matter what. It's maybe giving the commission another tool and to lower ratepayer costs. And so keep going if you wish. I didn't mean to hijack you.
Mr. Chairman, thank you. Is this a tool that you have in other states now that you are exercising?
Go ahead.
And Mr. Chairman, Representative, we do have the law in the other states, and some of the other states. So California has a law, Oregon has a law. It was specifically associated with storms. Idaho has a law that was fairly broad. I believe it encompasses energy costs. We have not utilized the tool in any of our other states. We are working to get it hopefully implemented in all of our states if possible.
Fair enough. Why don't we hear from others about this, and appreciate it, and might get you back up here, and we'll talk about what we're going to do as a committee, and that's open-ended, believe me. So, Mr. Bush. And all you wallflowers back there, you have to get ready. See, one man is the equal of three.
Excuse me. You caught me there, Mr. Chairman, sorry. Mr. Chairman, David Bush, Black Hills Energy. I'm not one man. I have a colleague online. If we could let in Tom Stevens. He's our vice president and our treasurer for Black Hills Energy. He is the expert for us on this topic. We are in support and in favor of this issue, however, and so I'll let Mr. Stevens, once he comes in, give his comments and kind of cover the.
Very good. He seems to be coming in now. Mr. Stevens, welcome. Can you hear us?
Yes, good morning, Chairman.
Go ahead.
Well, good morning. Thank you for the opportunity for allowing me to attend virtually this morning. I'll start with just very brief comments and then certainly open it up to any questions the committee has. Appreciate my colleague, Ms. Koblia, giving a good overview just a few moments ago. From Black Hills Energy's perspective, I'll just say that we see securitization in this particular bill as having kind of two key values, which have been discussed. One of them is it can provide a lower cost of financing for certain types of costs that a utility may incur. Traditionally, storms that might incur significant, immediate, one-time costs. Storm Uri was referenced earlier as an example. Those types of events can put significant pressure on the utility's financial integrity, but also be impactful to utilities' customers' bills if recovered under a short time frame. And so securitization is a tool that can provide for a lower cost financing to allow a longer recovery period, minimizing the impact to utility customers' bills. And so it's really about that lower cost option and maintaining the financial integrity of a utility. Much of the discussion I've heard this morning highlights that utilities, including Black Hills Energy, have fairly substantial capital expenditure needs that require funding from the debt and equity markets. And in order to maintain a healthy balance sheet, when these types of large events occur, we need to be able to quickly either move those obligations off of our balance sheet, which in this case securitization would allow, so that we are in a position to finance our capital investments at a reasonable cost of financing. So I'm going to stop there just to highlight those two primary reasons why we support this legislation. We do have it in some of our other states. We have not yet utilized it, and would be glad to comment on any of the questions you might have.
Thank you very much, Mr. Stevens. Questions for Mr. Stevens? Mr. Stevens, I have one. When you mentioned that it would come off your books, it does sort of in one sense. The asset is not on that part of your books, but I think you would be still expecting to earn a return on that asset being in service in your utility. So it's on the books in a regulatory sense, right? You're not thinking of not having it be rate-based.
Yeah, so great question, Mr. Chairman. If I take the example, and I'll use Storm Uri because that was an actual example in Wyoming where we incurred a substantial amount of costs. The commission authorized approval over 3 years. We're just ending that right now. But that was a case where we evaluated across our states, could securitization play a role in lowering costs for customers? Had we had legislation and had the economics justified the use of securitization, that would have been a bucket of dollars that we would not have been seeking a return on while we were recovering them. It truly would have been financed through that vehicle at a cost of debt that is a lower cost of debt than we can normally secure because of this discussion we had earlier about it's a lower risk to bondholders than traditional utility debt. And so in that example, Mr. Chairman, no, we would not be seeking a return in our rate base for that asset. And the credit rating agencies look through that obligation. So that's a key part of the value from a financial integrity, is that the credit rating agencies do not view that obligation negatively against our credit metrics.
Very good, thank you. That helps me a lot. And my mind is going down the route of, well, what is the term of these instruments? Is this something that you expectedly would be paid off? You're not going to renew bonds and extend them probably. You pay off these bonds. At that time, would you seek to bring the assets into the rate base?
Yes, great question, Mr. Chairman. I'll use the same example. If there was a 10-year recovery period, so I've seen recovery periods of 10 years or 20 years, at the end of that recovery period, that asset is gone, essentially. You have fully, we, the utility, ultimately our bondholders in this case, have fully recovered all of those costs, and there is now no longer an asset to recover from our utility customers.
I see. Okay, that helps a lot, actually. Thank you very much. Any other questions for Mr. Stevens? Any questions? Thank you, Mr. Stevens.
You're welcome. Thank you.
Mr. Bush, anything else from you?
No, Mr. Chairman, thank you for the opportunity, and if there's any questions, let me know.
Thank you, Mr. Bush. Let's keep hearing public testimony. Anybody else like to address this issue? Mr. Nelson? Is there going to be anybody else in the audience on this? I know you're excited about it. Oh, yes, sir. Okay, Mr. Anelius. Thank you. I should have got you earlier, sir. No, well, you're fine. You take up a lot of room, so we'll just take you first. I mean, you fill up a room.
Wow. Like Mr. Bush, I'm not sure how to take that comment.
I meant your aura.
Mr. Chairman,
Go ahead.
members of the committee, again, my name is Thor Nelson. I'm here today on behalf of the Wyoming Industrial Energy Consumers, which I should have said earlier, but for those who may not know, that's a coalition of large industrial energy consumers in the state of Wyoming, companies who are generally oil and gas companies, mining companies, chemical plants, other industrial processes, who collectively consume a lot of power in the state, and so who are keenly interested in maintaining reasonable electric rates as well as reliable and quality service. Relative to securitization, I have a couple of comments that I will share with the committee today. First, as a general principle, WIAC believes that there are times and circumstances when securitization can be utilized for the benefit of utility customers. The best and easiest example to share with when securitization makes sense is in the context of a retiring generation power plant. And this is the instance when securitization has probably been used the most frequently. And the idea is this: you have a power plant that is retiring and so will no longer be in service and used, but that power plant has a remaining balance that needs to be paid by customers. And the idea is to take that remaining balance and transform it from a bucket of dollars that you pay back to the utility at the utility's authorized rate of return into a balance that you pay back to the utility at a lower cost of debt. And so there's savings. You have this bucket of dollars that has to get paid back. If you can finance it more cheaply, customers have savings and everybody is happy. And so that's the case which is the most simple to explain, and I think the case where securitization makes the most sense. Having said that, I do want to caution the committee that there are, if you expand the scope of when you do securitization, you raise a number of very important and challenging questions. For example, when you expand securitization, instead of taking a physical asset and you use it to pay back an expense like higher fuel costs that has been converted to an asset through a mechanism, what we call creating a regulatory asset, which is just a bucket of dollars that's not tied to an actual plant or a facility, but rather is just a bucket of dollars that is converted from an expense, which ordinarily is paid back to the utility in a single year, into what's called a regulatory asset, which is then paid back to the utility over a period of time. And with things like fuel costs during storms, the reason why this sometimes happens is because it is felt that an expense that is paid back over 1 year would cause undue harm to customers because of rate shock. And it's a very high increase in a very short period of time. But if you take that 1 year worth of expense, convert it into a regulatory asset that is paid back over time, and then securitize it so that the rate of return that you are paying it back over is less than the utility's authorized return, then maybe the whole thing makes some sense. But that, anytime you start talking about ordinary expenses that are converted into a regulatory asset and then paid back over time, the questions become a lot more complicated about whether or not that's a good deal for customers or not, as compared to a physical asset that is being taken out of service where there's a remaining balance. That's the easier case. Now, because these things are complicated, while WIAC does not object to the idea of putting into law a tool to allow utilities to securitize, we think that it is very important that that tool be put into place first with customer protections. I observed in the earlier discussion that was held between Chairman Case and Ms. Koblia, the notion that there is this assumption that the utility will be subject to a consideration of whether or not this whole plan is in the public interest. Well, that assumption isn't actually written into this bill. And I will compare what is in the bill that is before you as compared to, for example, a securitization statute in place in Colorado, which has been around for a while. And in the Colorado language, which is common in some other states as well, the bill says that securitization will only be done when it will result in rates that are just and reasonable, when it's consistent with the public interest, when the mechanism itself is prudent and reasonable in that it will provide substantial, tangible, and quantifiable savings to customers or other benefits to customers that are greater than the benefits that are possible without securitization. And it further goes on to say that the securitization will only be allowed when it will either materially lower the overall cost to customers or avoid or mitigate rate impacts to customers as compared to traditional rate making. So these foundational principles, which I agree, I would hope and assume that the commission would put into place. But from WIAC's perspective, we would feel more comfortable if this legislative tool were packaged with a set of expectations that this will only be done when there will be material customer benefit in the form of either lower costs or reduced rate impacts, and when it is otherwise reasonable and in the public interest. So we would ask that the committee consider in this process somewhere, finding a way to add those types of consumer protections. Secondly, we are concerned about the scope of the bill. Many states, as Ms. Koblia mentioned, Idaho has limitations on the types of costs that can be securitized. Colorado has limitations on the types of costs that can be securitized. That's something which I think the committee should carefully consider. As I indicated, if you're talking about a retiring asset, that's pretty straightforward. If you're talking about an expense for which there is an existing tracker mechanism, like a fuel cost, where you know the customers are going to pay it, it's just a question of when, that's something else. But when you're talking about an expense that is not subject to a tracker, and I'll give you the example of wildfire mitigation expenses, which, at least as we sit here today in Wyoming, is not subject to tracking mechanisms. Converting those kinds of one-time, one-year expenses, which ordinarily are not captured in the utility rate process because it's just part of the general rates that everybody pays, and those expenses change over time. Transforming those into a securitized asset essentially creates a tracker for expenses which previously did not have one. And that's something that should only be done, I think, very carefully and under very limited circumstances. And so I think there may be reason for the committee to consider being more targeted in the scope of the kinds of costs that would be eligible for this particular treatment. Beyond those two broad concerns, I will mention a couple of specific concerns about the language in the bill specifically. First of all, I'll call your attention to page 2 of the bill, and I'll just sort of walk through these in the order in which they appear. In page 2 of the bill, we have a concern with the language that appears on lines 9 and 10 in the definition of bond. And the language in particular, I'll call your attention to, says that, actually starting on line 6, that the bond is a debt security that's issued and approved to pay utility costs, check. And then here it says, whether those costs are incurred prior to or after the issuance of the bond. And it is the or after part of this that causes me some heartburn. If you'll recall Ms. Koblia's testimony where she said that these are prudently incurred costs that the commission has decided have been prudent. Well, by definition, you can't decide a cost is prudent before it's actually been incurred. And if you take in at its face value, the notion that you would securitize a cost that is yet to be incurred, and having securitized that, you then guarantee that utility customers will be on the hook to pay for that, makes it very difficult for me to figure out how you would actually figure out from the regulatory perspective that the costs were reasonable. And so that timing issue, I think, is one that I would encourage the committee to carefully consider. Turning to page 3, I will highlight one maybe small point, but a point. In the testimony that Rocky Mountain Power offered, it was indicated that this is a tool for investor-owned utilities. I will call your attention on page 3, line 10. That actually doesn't exist as a limitation in the bill. The bill as drafted applies to all electric and gas utilities in the state, which would include our cooperative utilities, municipal utilities in theory. I mean, all of them would in theory be eligible for this. Now, I don't represent clients and people outside of Rocky Mountain Power, so that is sort of not my issue to bring before you, but I just wanted to highlight that if you look carefully at the language, this is broader than what I think it may have been intended to be, perhaps. But in any event, the effect of this would be to apply to all of the utilities. And that creates an oddity because, of course, not all utilities are rate regulated by the commission. And so if you have a unrate regulated utility, I don't know how the commission would be in a position to evaluate whether it made sense from the utility customer perspective, whether to order the securitization or not. And so that's maybe something that should be considered, and perhaps a more narrow definition of to whom this would apply be considered. Next, staying on page 3, there is a requirement in the legislation that the application for financing order be approved within 45 days. This gives me major heartburn. These are very serious questions, and we're talking about the idea of transforming costs in the order of magnitude of tens of millions, maybe even hundreds of millions of dollars, and transforming those into an absolute obligation and creating an alternative recovery mechanism as compared to ordinary rate making. And I will add here 2 things. One, I think it was very, very correct to say that the cost allocation issue from the multi-state protocol for Rocky Mountain Power, that's a big question, because once you, in the old regime, the multi-state protocol, that regime changed cost allocations over time as loads amongst and between the different states changed. And so if Wyoming grew or shrunk, the share of costs would grow or shrink. If you do a securitization, you need to lock in whatever is that bucket of costs that's going to be paid by Wyoming customers. And you will take that away from whatever the allocation system is in place at that time. And that's a complex issue that I don't know we can sort out in 45 days. In addition to that, I will note that right above the place where there's the 45 days, you'll see that there is this concept of securitization property. And that is that there may be collateral that secures the full and timely payment of all bond costs owed on a bond issued under this section. Now, what that property is left undefined and presumably subject to the application. But to the extent the securitization property includes, for example, any physical assets owned by the utility, that creates a very serious set of questions about how that impacts the cost allocations of the system and whether it is Wyoming's right to securitize a Wyoming obligation on assets that are currently used to serve all 6 states. I'm not here to tell you that you can't figure it out. I'm here to tell you you can't figure that out in 45 days. I think that these are very complicated questions with very high stakes, and I would strongly encourage the process not to have a time limitation so that the commission can take whatever time it needs to ascertain whether or not this is the right thing to do or not. Skipping over to page 5. Here on page 5, and I'll say this repeats itself a couple of other places through the course of the bill, let me call your attention to the sentence that, section E. So section E is a discussion in the bill which allows for a tracking mechanism to make sure that the costs that are paid by customers in rates match up with the amount of the securitized expense or asset. And that's right. You need to make sure that there is a tracker mechanism in order to make sure that customers neither under nor overpay the amount that is being securitized. But the part that gives me some heartburn, and in all honesty, because this dropped so recently, I haven't had a chance to talk with Rocky Mountain Power to figure out what this means, so I'll just flag it. Where it says that the adjustment procedure, now looking at line 14, shall provide for adjustments to be made upon application by the affected utility or assignee. And this assignee concept appears a couple places in the bill. Now, when we're talking about the bond and the bond holders, I understand those bonds can be assigned. I don't know what it means to have an assignee for an entity to make an application for approval of rates from customers. And so that piece of the legislation causes me some concern.
And Mr. Nelson, I agree with you, but I think there was reference in the early testimony of Rocky Mountain Power that it's actually a separate entity, liability limited entity. I heard that anyway.
I agree that, so when you do the securitization, you will create a special purpose entity in order to hold those assets. But that special purpose entity is not charging rates to Wyoming customers. That special purpose entity should not be filing an application with the commission to approve rate changes. So there definitely is an entity, but I don't understand why that entity would have the assigned right to go to the commission and get rates charged, because the customers in Wyoming aren't customers of the special purpose entity. We're customers of the utility.
Yeah. So I'm going to take a little time out here. I can see a time crunch coming upon us. And I know that our friends, I'm not cutting you off, I promise. Our friends at Rocky Mountain Power are not available after lunch. So we kind of have to do both bills. I can also guarantee to everybody that we're not going to work these bills. They're not going to be, they're not going to be committee bills. So can we approach it maybe with a different idea? That we're just kind of having a workshop about this, that this is too soon for prime time, but this bill could come about as an individual bill. I'm not saying no, but I'm just saying this committee, I don't think will be doing it unless they exert that they do. So to you, Mr. Nelson, maybe we could shorten it all up a little bit.
Thank you, Mr. Chairman, and I will be very brief. Otherwise, I will leave you with this comment. As I mentioned, from WIAC's perspective, we think this is a tool that can be useful. We think, however, that there is much work that needs to be done on this draft. We are happy to work with Rocky Mountain Power, and if somebody on this committee is interested in sponsoring this legislation, we're happy to work with you to incorporate these suggestions, but we appreciate the chance to comment on the legislation. Thank you.
Perfect. Representative Yen.
Mr. Chairman, thank you, Mr. Nielsen. I very much appreciate all of those comments. The one question, I mean, since we're not going to move the bill, my only real question is, moving forward, if for some reason the multi-state protocol does not get renewed or negotiated or whatever, does WIAC generally believe that rates will go up or down?
Mr. Nelson.
Mr. Chairman, Representative Yin, so I will give you a flippant answer and then a real answer. The real answer is if I were in charge of how we do allocation, they would go down in Wyoming. But the answer is it depends. And it hugely depends on what allocation system Rocky Mountain Power proposes and what allocation the commission approves. There certainly are arguments which we will advance that an allocation methodology should be adopted that would reduce costs. But there are arguments that others may advance that go the other direction, and it's just too early to tell.
Okay. Anybody else for Mr. Nelson? Very grateful, Mr. Nelson.
Thank you.
Hey, this is only the beginning. Who else would the commission like to address this? And then Mr. Ornelas. And I'm sorry about the time constraint. It's just always, it's the Corporations Committee that we start running out of time. We're going to try to get this other bill before lunch too.
Mr. Chairman, thank you.
Go
I'll
ahead.
make it quick. Chris Petrie from the Public Service Commission. Of course, any mechanisms that allow for lower cost financing of prudent utility expenses and costs are interesting to us and important to look into. We need every avenue that we can use to keep costs down. I do want to pile on for just a moment on something that Mr. Nelson pointed out. The time frame allowed for these proceedings is troubling to me. Generally, everything that comes in front of the Public Service Commission is a contested case under the Wyoming Administrative Procedure Act. And that means notice, intervention, opportunity for hearing. And when a case is consequential, that becomes especially important. You know, we can do a small gas company pass on, and it doesn't really require the intervention of other parties and the provision of additional information or testimony or anything like that normally, because it's a relatively simple, straightforward thing. These could be other than that. These could be consequential and important matters that the commission would benefit from participation by other parties, like the WIAC, the OCA, and anybody else who wants to come forward and do that. I just call your attention to the existing security statute, which is 37.6.102, and that provides that after such hearing and upon such notice as the commission may prescribe, then the commission will approve or not other security filings, not this particular type, but any incurring of debt that involves the use of the utilities assets as security. And that we have generally taken as something other than requiring a full-on contested case proceeding under the APA. So there's notice. If you're paying attention, you can see that the commission is going to consider these things. And then there is an opportunity for discussion, public comment, and a hearing of a type in the commission's open meeting proceedings. The other part of this that's not present in this bill that you're discussing is that there is the opportunity for an extension of time for good cause shown. So there's a lack of clarity about what the expectation is for the commission to conduct its process. I'd agree that a full-on contested case proceeding can't realistically be accomplished in 45 days. That's not realistic. You know, we usually give interveners 30 days to be notified of an application and to approach the commission for intervention or to comment. So that's a really compressed time frame if you mean for this to be an APA contested case type proceeding. And then the other bit is that There's no provision for extending the time for good cause, which we try to avoid that very much in regular securities filings, but it does occur. So occasionally, we have to put off a decision on a securities filing beyond 30 days for a variety of reasons, but it's a short time frame to get important things done.
Thank you, Mr. Petrie. Questions for Mr. Petrie? Senator Land?
Just real quickly, Mr. Petrie, by its very nature, it sounds like the reason we would take up, the securing of these kind of bonds would be in emergency situations. Do you have in place, I'm sure you do, an expedited way of going about things? Am I right on both of those counts?
Mr. Petrie?
Mr. Chairman, Senator Landon, the commission can and does expedite a variety of proceedings for a variety of reasons. You can't expedite every proceeding, but certainly we can and we do, and it requires the cooperation and the devotion to the cause of the other parties, but yes, we do. So you're correct.
Anybody else for Mr. Petrie? Mr. Petrie, my question would be, your existing securitization ability under 376102, could you envision, it says such public utilities shall, by written petition filed with the commission and setting forth the pertinent facts involved, make application to the commission for an order authorizing the proposed issue, assumption, or guarantee of securities, and the application of the proceeds thereof for the purposes specified. In some sense, I'm thinking, well, maybe under that deal, you can do everything in this bill now. Is that possible?
Mr. Chairman, I see that as possible. Of course, it's not explicit, and it doesn't give us a legislative prescription for the details, but yes, this is a pretty broad authority to consider and approve securities issued by a utility. So it's at least arguable that the commission could do what's provided for here. Maybe a couple of exceptions like the irrevocability. I don't know that the commission sitting today can bind a future commission that doesn't like what we did, whereas this would provide for that degree of certainty. So that might be a question that would interfere with the rating that this security would get. So you might leave some cheaper borrowing, so to speak, on the table without that explicit guarantee. But
in your memory of the commission, and we know, of course, you were the general counsel before you were a commissioner. I guess before that, were you a staffer too? I'm trying to remember. You've been there a long time. Do you remember this clause being used in a way to achieve preferential financing for particular activities of a utilities business? I'm 376102.
Mr. Chairman, I'm sorry, I don't recall any occasion for that stands out that way.
Okay. All right, fair enough. Something to think about, though.
But, Mr. Chairman, I also don't recall an application that would resemble any kind of securitization
Package.
package like that either.
Question for Mr. Petrie? Representative Ottman.
Thank you, Mr. Chairman. Mr. Petrie, it's good to see you. If you could just help me discern through this, because there's a lot of information going on here this morning, and it's very important and it's very large. So what I'm wondering is, in the past, we have talked about rates and how that a company has to consider all of their customers and how that profitability or the handling of those expenses would be charged. And I saw that it was an umbrella of customers, whereas this seems to be, here in Wyoming, we would be under that umbrella as well for other costs of decisions from a company, but we also would be responsible for the costs incurred in our own state, and other entities would not be part of that. We wouldn't be under that umbrella anymore. Do you understand what I'm asking?
Mr.
Mr.
Petrie.
Chairman, Representative Ottman, I think I understand the question. And if you're talking about the allocation of costs amongst the various states that a utility like Rocky Mountain Power operates under and operates in, and there are costs that are system costs, undeniably system costs. For example, you've got big coal-fired power plants in the state, or other big assets, other places on the system. No individual state, even the state where it's located, requires all of that, and hence shouldn't be required to pay for all of that. So all of those facilities and activities that are system facilities and system assets are going to be divided up amongst the states where service is provided one way or another. And so even if there's not a mechanism in place such as the multi-state protocol that we've talked about many times, there will still be a process in rate cases where the commission will have to hear from the company what they propose to allocate to us, and then we'll have to decide whether they are being reasonable about it and whether those are the correct costs to be paid for by Wyoming customers. So there's still, it'll look a little bit different, and a rate case might look a little bit more complicated, but there's still going to be a system that has system costs, and then there's going to be a division of those costs amongst the states where the customers consume the power.
Thank you. You guys were in a terrible time crunch. Anything else for the commission? Okay. Who else would like to address the committee on this bill? Anybody else? I'm not seeing anybody else or seeing anybody online, so what I'm kind of proposing, it's not prime time for this committee, but there's something here, and I think we all see that. So folks that might be interested in trying to bring a bill for this session that want to participate, welcome your help and effort. Maybe we could have a bit of a working group to try to bring it to a more reasonable deal as an individual bill for the session, a group of people. So if you're interested in helping with that, please let me know, and we could maybe get some of these fine minds here in this audience to help us with that. Mr. Ornelius, I didn't mean to cut you off. I'm so sorry. We're good? Yeah, lunch wins everything. So let's hear Rocky Mountain Power and their other proposal. So fair to say that people are intrigued with this idea, they see potential benefits, we'll explore it further, and possibly as an individual effort. Back to you.
Thank you, Mr. Chairman. On the previous issue, we'll have a handful of conversations and work through all those concerns and hopefully bring something forward soon. And I appreciate that, and I appreciate moving this forward. The next conversation. Tom Carter, Vice President, Government Affairs, Rocky Mountain Power. Joelle Stewart, Senior Vice President of Regulation. Yes, okay. Regulation, regulatory, important stuff. We're seeing a troubling trend throughout the country, and it has to do with what we call hyperscaling large loads. I'm sure you all are seeing this as well. We've seen a number of stories throughout in the media and the press. And these are not our typical loads that we deal with, even large loads that we deal with here in Wyoming. These are enormous loads, 100 megawatts, 200 megawatts, even to the tune of a gigawatt or more. And they want to come online in a hyper speed. So 3 years, 5 years, gigawatts of power. And this is being fueled by AI and the development of artificial intelligence. I want it to be clear that we are agnostic on this. We think that we'd love to serve, and we're in the selling of power business. But we have some concerns currently because the the current regulatory structure and the current operations of regulated utilities did not even imagine this type of hypergrowth. And so we've come to the state with a proposal that does a couple of things. First thing that it does is protect current customers and current growth. We want to be in the business of protecting the normal growth that we are used to, that we're in the business of, that we've done over 100 years. As Chairman Case mentioned, you know, some of the best power plants we've built over the last period of time have been through efficiencies, and we just haven't been in the business of like large scale growth and development of generation capacity. And so when the principles, one of the guiding principles, as I mentioned, I'm sorry, I'm trying to go as fast as I can, is to protect current customers and clear a path that the normal growth that I'm sure you all are hearing about from your constituents, there has a pathway forward for that normal growth. The second one is to create a structure by which these hyper scaling large loads will carry the risk and the cost. The risk and the cost will be assigned to those loads, to that development. Our concern, and we're seeing this, and there are cases currently throughout the country in Ohio and Oregon and some throughout the South, seeing this in our current system as well, is that there are ambiguities in the current tariffs that some of these loads are trying to get in and get involved, and then we're put in a position where we have to serve them, and then the rest of their load growth could then potentially be socialized amongst our current base. And that, to me and to us, could be problematic for customers and rate base, and then additional growth. So what we'd like to see and what we'd like to do is to do something that is proactive here in Wyoming. Now, let me just say this. Wyoming has already been proactive in this. Wyoming has allowed for utilities to enter into contracts with these large loads to find a way forward. We think that we're looking at legislation that would tighten that up, that would force a load of a certain size, and the legislation we're proposing at 75 megawatts or higher, new growth, new loads, to establish appropriate safeguards that they would, that kind of a new mechanism where if you come online, the risk and the cost would of course be assigned to you. We would create a contract between the utility and the customer, and it'd be done in a special way so that there is nothing, or nothing would be assigned to our current customers and growth. That bifurcation would allow for us to continue to work on the issues that are at hand, which is normal growth, as well as serve or potentially serve this new growth that we're talking about. We would require new large load requests into special contracts subject to commission approval that include commercially reasonable return or individual investments and recovery outside of the general rate base. And we want a clear path for the utility to recover O&M, taxes, fuels, et cetera, for expansion of assets as part of state cost to serve for facilities developed under special contracts. And we think that having legislation that would establish large load process with clear development and regulatory timelines would be beneficial to the state of Wyoming. There's a lot of pressure on electricity right now, a lot. And there's a lot of pressure on our business. And while this isn't a uniquely Wyoming problem, this has become a bit of an arms race. Who's going to build the biggest brain fastest? And the only thing what they're telling us is there are a number of things holding them back. Not the only thing isn't electricity, but it's one of the things. And our ability as a state, the state of Wyoming, to attract the right customers will put Wyoming in a position to be successful. Our system has somewhere between 7 and 10 gigawatts of requests for this type of load throughout our 6-state system. I don't know if all those requests will come to pass, But I know that the ones that are fully capitalized, that are interested in participating in a prescribed process, are the ones that our states want. And having a good process put in place that directs them through, and makes it so they're not competing with the growth that we usually plan for, and protects our current customers is the best way to do it. And so I know we're not going to discuss or debate the legislation in front of you, but we want to make sure this is on everybody's radar, that AI is coming, and that electricity is a big part of this, but we don't want to put in a position as a utility where we have to socialize the cost to develop this. We want to make sure that the cost and the risk follows the cost and risk causer. And I can pause there to answer any questions. And Joelle's here to help me answer any of those questions.
Thank you. Any questions for Mr. Carter? Mr. Carter, it might help if you would put in perspective, do you have an example of what, say, in terms of the equivalence at a municipality, what is a 75 megawatt size city? Community?
Well,
Anybody know that answer?
I can give you, our load in Wyoming is about a gigawatt.
About a gigawatt.
And so when we have one customer that like 1.4 gigawatts.
So that's
by
1,000 megawatts.
1,000 megawatts. We have, yeah, sorry, Mr. Chairman.
So it's not 10%, but about 7.5% of the entire load of the state of Wyoming being requested by one consumer.
Yeah, Mr. Chairman, when we're talking about adding states into our portfolio.
Yeah.
And that is, for 100 years, we were in the business of 5% growth, 2% growth, 3% growth. We have to have a process because we have an investor who stands ready to put money into growth, but we have to be able to recover our costs, have a reasonable return, and protect the investor, but also, as important, protect the current customers. And the current customers need to have a surety that if this comes online, they're not going to be paying for this type of development.
And committee, just to help get your minds around this a little bit more, most of Rocky Mountain Power Territory's load is industrial load. It's up north of 70%, for example, just rough numbers here. So 30% is everything else. So when they talk about a gigawatt, 1,000 megawatts, most of that goes to the industrial. So all the communities in Wyoming served by Rocky Mountain Power work out to be maybe 250 megawatts. All the communities that you serve together. Rough numbers, really rough numbers. But so Laramie would be much smaller, for example, than 75 megawatts. So these are just big loads that want to connect into the utility system, a year from now, for example. That's what we're talking about. And it's how do we share that cost with all the customers? How much of the new transmission or the new energy is socialized? How much is paid specifically by the new customer? That's the kind of thing we're trying to grasp with. And they have multiple requests of this size. So Senator Scott.
Mr. Chairman, just clarifying, you spoke a little earlier, 7 to 10 gigawatts of requests.
System.
Is that across all 6 states? Is that just the 3 states of Rocky Mountain Power? And what's the time frame involved?
Yeah, so that's, Mr. Chairman,
Go ahead.
Senator Scott, that is that is all 6 states. I couldn't speak intelligently as to where each of those loads are. I have a feeling, and we have this rule, never lie, never guess, and so I don't want to guess. I will say that is around, unless, Joelle, you have a better answer for me.
Ms. Stewart, welcome, jump in.
Thank you, Chairman. It's primarily right now in Oregon and Utah that most of our load requests are. But we see the demands keep coming in and we expect it to grow. So we want to be ready across our states to address it as it comes to Wyoming.
And the load is still addressed system-wide. We know that an Oregon new load isn't served with generation from Oregon. Far from it. Most of that generation will probably come from Wyoming, so. Got to think about that too. Anything else you want to add? Any questions by the committee? Let's hear what the public has to say about this one. It's probably in the same boat. Let's get Mr. Ornelius first because I've neglected him this morning. He can kind of get his shots all around. Go ahead.
Chairman, members of the committee, my name is Anthony Ornelas. I'm the administrator of the Wyoming Office of Consumer Advocate. To a large extent, I agree with what you've heard this morning in relation to the large load or extra large loads that Rocky Mountain Power has discussed. They are real. They are concerning. We are struggling as an industry to figure out how to best serve these while also protect the native load or existing load customers. Where I tend to disagree is that there's actually a need for the bill that's been proposed. Take you on a quick history lesson. 2015-16 timeframe, we had the first data center start knocking on the doors of Wyoming, served by Cheyenne Light Fuel and Power. They worked extensively with the OCA and had it approved through the Public Service Commission, what they call an LPCS tariff. It serves data centers today, as you heard, upwards of 7 of them in the Cheyenne area. So we have a way to do this through tariffs and under the existing toolbox that the commission has. 2019, the Wyoming legislature passed Wyoming Statute 373116. This is a special contract customer legislation. It provides parameters for utilities to enter into service through special contracts that meet certain criteria that are then approved by the Public Service Commission. So again, we already have this toolbox. It could be sized to scale, it could be, amended or changed, or a new tariff could be created to serve these loads. Again, we do not need this. Shortly after the 2019 legislation, we had Rocky Mountain Power actually file a new tariff request, Tariff Schedule 400. It has been approved. It is in existence. It is for minimum loads. They have to be greater than 10 megawatts. They have to demonstrate unique loads or characteristics or circumstances. There's certain minimal terms of service and rates. A key provision I find, though, different from the Schedule 400 tariff that exists and the proposed legislation that you may or may not have seen because it just recently dropped, is that I only saw language in the new proposed legislation about the need to cover incremental cost of these new loads, these new exceedingly large loads. Under the prior legislation 373116 and under the Rocky Mountain Power Schedule 400, not only are incremental loads shielded from being socialized, as we've been using that term, but these new large loads also have to contribute to the fixed cost of the system or provide some other benefit to the system. So for instance, there are office buildings in Oregon and Utah that Rocky Mountain Power utilizes. There's salaries and benefits of the fine professionals in this room. Those are not necessarily incremental to a large load, but these new large loads should pay a share of those type of costs. So that protection for consumers was captured in Statute 373116, as well as Rocky Mountain Power Schedule 400. I feel we have similar protections in the Cheyenne Light Fuel and Power LPCS tariff. All of that is a long-winded way of saying I do not believe this tariff is needed, and certainly in its existence not ready for prime time. So I will stop there and take any questions that might arise. Thank you.
Any questions for Mr. Ornelas? So I think Rocky Mountain Power, when they set this up, they said basically, we like that existing framework, but it's kind of an optional framework. We'd like to make it mandatory for extra big loads. You don't agree with that characterization, or help me with that? Because that seems to be the point where you miss, or where there's a disconnect. I didn't mean you miss.
I think I do disagree to some extent. Again, we have existing legislation that gives them the right to engage in these service contracts subject to some basic terms and conditions. So they already have that right.
So if a customer wanted to come in though and didn't want to participate in a service contract, just wanted to come off the tariff, and they were just gigantic, what protections do the rest of the ratepayers have about you having to take them on under the tariff?
If I've misrepresented or misunderstood your question, but I will try, is that both the legislation and the tariffs that we have in place have those protections,
About size.
separations cut into them. So they have thresholds, so they do require them to be large loads. The one instance is 10 megawatts, but you can certainly scale that up to 50 or 100 or a gigawatt, whatever the size might need. And then we have protections under the terms and service of who pays for what types of network upgrades, additional facility costs, operating costs, things of that nature as well. And again, the big difference is the prior legislation required new large loads to contribute to the fixed cost of the existing system as well. This current proposal does not.
Okay, it makes sense. Thank you. Any other questions for the gentleman? Thank you.
Thank you.
Busy again. Mr. Taylor. Well, Mr. Taylor, this is the best testimony you've ever given. Mr. Nelson. Go ahead, Mr. Nelson.
Good afternoon. Thor Nelson with the Wyoming Industrial Energy Consumers. I will be pithy. WIAC has serious concerns with this legislation. We are pleased that it's not advancing today, it sounds like, so that's good. I will just summarize quickly some of the issues we have. First, I will not repeat, but I agree entirely with Mr. O'Nellis's testimony regarding the fact that there are existing tools in place that can be utilized and should be utilized to address this. And if Rocky Mountain Power or any other utility thinks those tools are inadequate, there's a forum for them to come and get different tools and change the tariffs and change the arrangements. As a practical matter, every customer that is greater than 1 megawatt must have a contract with the utility. It's just a question of what's in those contracts and how that contract works. Further, every new customer that comes relative to Rocky Mountain Power is required to pay their cost to connect to the system. So customers pay all of those interconnection costs. The question becomes whether or not they should also pay the costs different from everybody else of the stuff deeper in the system, the backbone transmission system, the generation system. Historically, Wyoming has operated under a principle, along with most of the other states, of average cost pricing. That is to say that all customers in a given group pay the same average cost for the transmission and the generation system. They all pay their unique cost to connect to the network. But once you get past that point of connection, there's an average cost system. And there's reasons for that which we think ought to be carefully considered. Now, having said all of that, our real problem with this legislation is not that there isn't a concern. We think that there is reason to be careful and reason to make sure that existing customers are being treated fairly relative to new customers. But this bill overreaches. And I just want to highlight 3 things that are at the core of the concern of the legislation. First, if you look at page 3 of the legislation, the legislation proposes at section B on lines 15 through 22 that all other provisions of this title, I'm looking now at line 20, all other provisions of this title do not apply to these loads, and that only this provision applies. What that means is that if you are a large customer looking to come to Wyoming and have load, or you're in Wyoming and you want to expand your facilities and you are covered by this legislation, all of the other protections of the law no longer apply to you. And those include, importantly, the right to file a complaint with the commission if you think you are being treated unfairly by the utility. This legislation would eliminate all of those rights and all of those protections and replace it with a contract. Now, and here's the other thing about this contract, now turning to page 5. The contract, by definition, must be something that the utility consents to. The commission is not empowered in this language to force Rocky Mountain Power to sign a contract. They have to agree to it. And so that puts them in the driver's seat. And they can essentially dictate terms to the new loads in terms of what they are willing to do. And because no other provision of law is available, if the customer has a problem with that, there is no place for them to go. Now, you may say to yourself, but it's okay, because if you look at the bill at page 5, lines 4 through 8, it says that the contract will provide that there'll be service at the rates, terms, and conditions of the utilities tariff. However, here's the weird part about this legislation. It says unless otherwise specified by order of the commission, meaning if the contract provides for a different rate and that contract is approved by the commission, that's okay. But here's the tricky part about that. If you look at page 7 and 8 of the bill, it talks about in section J what the commission can do when they review a contract. And it gives very specific guidance in J part 1 that there's a requirement that you can consider whether or not other customers will have to pay. I'm going to focus on the word other customers. In section 2, it says that the contract has to, and then flip the page to page 8, can't, section 2A, jeopardize reliability. 2B, prevent the utility from being able to provide safe and reliable service to other customers. Or C, increase rates for existing customers. And then if you look at section K, it specifically says in line 17, other terms of the contract cannot be reviewed by the commission. So what is the term of the contract that's missing? The rate that's actually paid by the large customer. Everything the commission is empowered to review is how the contract affects everybody else. There is no ability in this for the commission to review the price actually paid by the 75 megawatt or bigger customer. Meaning that if the utility says to the customer, okay, I'm going to agree to serve you, but I will sign a contract only if you pay a 50% premium on the tariffed rate. The customer says, well, okay, if I have to, I'll sign that. Then you go to the section about the commission review, and the commission is not empowered to decide whether that's a fair rate for that customer or not. They can only decide whether that rate is sufficient to compensate for the costs of everybody else. And so at the end of the day, what this bill creates, possibly unintentionally, is essentially an unregulated monopoly for large loads. And that's not right. I will say this in conclusion. If Rocky Mountain Power or the other customers are unwilling or unable to serve loads in Wyoming, the answer is to go to a competitive market for those loads, which I've talked about with this committee before. The answer is not holding new customers hostage to the utility and its whims. I'll stand for any questions.
Thank you. Questions for Mr. Nelson? Senator Scott?
Well, Mr. Chairman, isn't that go elsewhere?
How about getting your mic on there, Senator Scott?
Isn't that go elsewhere argument almost inherent in dealing with a load of this size? That whether we're deregulated or not, if the local utility here in Wyoming is being unreasonable, they'll go to a different one in Nebraska or California or Oregon or wherever they can find one. Isn't that something that's sort of beyond our reach? That's the way the world's going to work at this level of this size of customer.
You know, Mr. Nelson will never answer that yes or no. Mr. Nelson?
Mr. Chairman, Senator Case, no. Just to get to you. So here's why. Here's why I say no. Under the way the law currently works, if you are a large or small customer and you feel that the rate or the terms and conditions being imposed upon you are unreasonable by the utility, you can go to the commission and ask the commission to decide what fair, just, and reasonable rates, terms, and conditions are before you make the decision to go somewhere else. If this proposed bill were to become legislation, what would happen is that those customers would no longer have that choice. They would be either take or leave what the utility offers or go somewhere else. And what I'm trying to preserve is the ability, as long as we're going to have a monopoly that's regulated, that regulation should apply, and customers, before they abandon Wyoming to another state, should be able to go to the commission and have them decide whether or not what the utility is proposing is right.
Thank you. Remind me again of the name of your organization that you represent?
Wyoming Industrial Energy Consumers.
Very good. Thank you very much. Good man.
Thank you.
Any other questions for Mr. Nelson? Mr. Bush? Welcome, Mr. Bush.
Thank you, Mr. Chairman. Always enjoy appearing before your committee, especially after Mr. Nelson. It's a hard act to follow. David Bush, Black Hills Energy, standing in support of the regulated utility model. But unless we want to go down deregulation today, I'll try to stick to the bill. As has been referenced, Mr. Ornelas did a brief history. So some of that is basically us, the data centers that came to, specifically Microsoft came to Cheyenne back in 2014, 2015. We worked with them, as I touched on earlier, to get a contract put in place that serves their needs and also serves our needs in the growth for Cheyenne and Laramie County and Wyoming, but also in protecting our existing customers from those large loads. In 2018-ish, we started seeing a lot of demand for, and some of the members of this committee know this really well, we had a certain class of customers that were being attracted to Wyoming, and they were looking for a lot of power. It was a load that we were interested in serving, but it was also potentially a load that would not stay very long. So investing in infrastructure and other generation was not what we felt would be in the best interest of other customers. So working with Chairman Case and others, we put together what's called the blockchain interruptible service tariff. Legislation enabled the tariff. We filed that tariff. We now have a customer that will be under that tariff soon here in Cheyenne. Very large load. There was I'll share this because it was made public. They're going to be at about 75 megawatts for the first phase of their project, which should be coming online soon. So would fit under the auspices of this bill as far as a large load, but it is under that filed tariff that we have with the commission, where they look at everything and make sure serving that load is not going to impact our other customers. So we've used that. Has been a lot of interesting back and forth. I haven't been in all the meetings, but I can certainly say that it's not always the utility that's at fault. Sometimes the customers are asking for things that are unreasonable. So in that case, we did feel to be in the right by using the tariff to protect our customers and say, we can't serve you under the terms that you're asking for. That's just not something we can do or interested in. But the tariff in place has worked well for us. It's worked well for our customers here in Cheyenne. We feel it's been a good decision by this legislature to put those protections in place, and we will continue to move forward with using those tariffs as much as we can for the growing, as the mayor said earlier, the data centers coming into Cheyenne. It's a great fit for us. It's a great fit for them and for the community. So we're going to continue to grow with them using these existing tariffs and the existing tools that we have that Mr. Ornelas touched on. Continuing to understand that the risk is out there for these larger loads, and we may need to address this down the line, and we can work with the other utilities, the commission, the legislature, everyone to make sure that we're continuing to protect those other customers from these large loads, but also doing the best that we can to attract those large loads.
Thank you, Mr. Bush. Questions for Mr. Bush? Seeing none.
Thank you, sir.
So, does anybody have any new testimony that would be very different? I'm not really trying to discourage you, but I kind of am. So committee, I think this is one that maybe we gotta let the parties think about a little bit more, and maybe our friends at Rocky Mountain Power would like to come back and talk to these people and maybe narrow the scope or see what you think. So with that, are there any other comments on the morning's work? Is there any other public comment online about the morning's work? Okay. We do get an hour and a half, Mr. Chairman.
Still?
Yes,
Roll
because
back?
we worked so hard. So can we come back at 2 and you'll get us right back on track?
All right.
Not as bad as it could have been. Thank you very much, everybody.